find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime. We can make a difference if we put in the time. Good evening, come and find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime. We can make a difference if we put in the time. Oh, we can make a difference if we put in the time. Good evening, come and find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime. We can make a difference if we put in the time. Good evening.
Hello, everyone. Welcome in. Happy Wednesday afternoon, evening, wherever you're at in the world. Early afternoon, late evening, mid-morning. Welcome into Wacky Wednesday. We had a heck of a day. Salty, welcome in. Thanks for joining me.
Hey, how are you?
I'm good. I'm still trying to process everything I saw and heard today.
Oh, yeah, me too, but on a different level.
Right?
These court
I
things,
heard.
crazy things happen in these court hearings, right? You're like, oh, I need a minute to process all this. I get it.
I am Joe Schmoe. I'm just your everyday Joe Schmoe, interested in true crime, mysteries, history. I have not been able to dive into my love of history as much as I want to because this true crime thing just like eats up so much of my
Dude,
time.
true crime is a full-time thing. If that's what you're, you know what I mean? If you're covering true crime, it can be a full-time thing. So that's why I just stick to the true crime. I don't know what else to cover. Not a whole lot interests me out there. It's funny. But I do like history. I do like history, though.
Well, history and some true crime has ties to history too.
Mm-hmm.
That's a whole other topic and a whole other rabbit hole we don't got time for today.
Yeah.
So you are over on your channel, and we'll drop your channel link in chat, airing the Karen retrial today, right?
Yeah, we've been airing it since right after Lori started, Karen started, so we've been doing that every day. Tomorrow we're gonna have to do a little different because I got to cover that Kohberger hearing, so I'll slip Long Crimes show tomorrow into my playlist to make up for me not covering tomorrow. It'll still be there for everybody who wants to go back and view it, but I'll have to view tomorrow's Karen Reed trial tomorrow night because I am doing Kohberger tomorrow. But yeah, we are covering it. Mm-hmm.
So I heard some things might have gone down today, like some things might have come to in that trial. Was it an interesting day?
It just shows there's way too many questions with evidence collection, chain of custody, and things of that nature happening. We also know that the other day when Yuri was testifying, remember when you came in and said into chat and you're like, if you could put a bubble over his head, what would it say? And the first thing to my mind was defeated. Well, by the end of the day, because of his testimony, he landed himself on the Brady list. That's why he was looking so. He sat there. Yeah, I read it on the channel, all the charges, everything he was put on the Brady list for. I can send you that later, but yeah, he knew when he was sitting there testifying that everything he said was about to get him into trouble. What's a fake website? What is she talking about?
That he's on the Brady list?
Okay. Well, it's out there. I went to those 3 different places and saw it, so I don't know. It was on the mainstream media feed too at one point, so I'll have to go check it out. But that's what they were saying was he was, and if you go and read some of the stuff, I'm surprised he's not on there. They were predicting it before he testified, so I don't know. I'll go look and see. Here's the thing about Karen Reed case that I don't like, and I'll go ahead and say it. And Dizzy, you probably know as well. There are way too many accounts out there right now, purposefully posting what they see as jokes. And to me, it's misinformation. It's not a joke, right? Why
Yeah.
do you need to do that? We don't have enough muddy waters as it is. Why do we have to have all of that? So I'm trying to ignore a lot of that right now.
Right. And as we say with all cases, and like Kresha and I say with the Mormon research we're doing, like going back to the early 90s, investigate for yourself. Like we're on here to say what we think and to put out our opinion and to do our research, and we'll share our research with you. But you're go do your own research too. And
yeah, I have no reason to disbelieve Dizzy at all. I get it. You live and breathe the case. I know. So I'm not saying you're wrong. I'm not saying I'm right. I'm just saying I'm tired of everybody putting out stuff that may or may not be fake as adults, expecting other adults to have to wade through the bull. I think that's weird, but okay. So.
Yeah, and I guess in the end, we all have to pick those channels that we don't follow anymore, that we unfollow once.
This was on Twitter. Yeah, this was on a Twitter feed that doesn't usually put out bad stuff, so I don't know. But then again, I don't. I've just noticed a lot of more not just parody accounts, but accounts that are just coming out and saying weird things on purpose. And I'm like, I don't understand why you even need to do all that. But okay, so maybe I should just start ignoring Twitter again too.
Yeah. And then I also heard, Lauren and her producer were at the hearing today, and her producer told me that something went down in Murdaugh too.
It did.
The court got charged with like felonies.
He's got 3 felonies.
Perjury and tampering and something else, maybe.
Well, we've known it was coming for a long time. She's been investigated heavily. She wrote a book. She did all kind of things, but I'm surprised it didn't come sooner than it did. I'm surprised it took this long. But yes, she was arrested and she is charged now with 3 felonies. And we don't want no egg ladies jury scandals either. You know what I mean? Why these messy adults? It's like, y'all sit down.
Just let justice take its course. I mean, in cases that are obvious, like Lori, like Murdaugh, like if something comes up in SS, like just jurors, court clerks, court staff, just leave it alone. Leave the jury alone. Jurors, leave the media alone for a while. Let it digest, let it process. Anyway.
Yeah, people, they can't help themselves, so we just have to learn to tune it out, I guess. Like I do most of the time anyway. I tune out the noise when I need to, especially when a court case hits the actual trial. I'm like, done with the noise. Just let me pay attention.
We had some noise today in Maricopa Superior Court. Oh my.
She got a little salty, did she?
If you want to identify yourself with that, feel free.
Hey,
I said it was spicy.
Lori Vallow's no match for this energy, and old girl knows it. Bring it, bring it, Miss Vallow. My portals are stronger than yours. That's all I got to say.
So I planned on going to the hearing today, and I did. I didn't know how early to go, because there were some days for trial when I had to show up at 5 o'clock in the morning. And I'm like, I'll be damned if I'm showing at 5 o'clock in the morning for this one, because it's just a hearing. It's in Judge Beresky's regular courtroom, 1104, which is in the main building, not in the South Tower. I'm like, and if I get there and they've moved it to the bigger one, then there's even more seating. So, but I got there like 8 o'clock and nobody else is there except Judge Beresky had a full docket before Lori's. So his docket started at 8:30. He had an hour and a half of cases before hers. So when they opened up the doors, I'm like, I'm just going to go sit in there because I'm either sitting outside in the waiting room chairs or I'm going to go inside and watch these cases. So I just went and parked my butt in the back corner, and it's a completely different atmosphere. So even though these are felony cases, and a lot of them are the same type of hearings, they're final trial management conferences. A lot of them, there were other pretrial hearings that went on, but most of them felony cases. And just to watch Judge Beresky's demeanor and how he dealt with these, like he is so even keeled.
God. Yeah, I like him.
And he knows the law really well. Like, so out of all those cases, there was one plea agreement. Most of the time there were continuations, and there were scheduling and all kinds of other, just like housekeeping matters, bookkeeping matters, like just keep the cases moving along till they actually get to trial or they reach a plea deal. So there was one plea deal today. And I'm going to say the words on my channel, and I don't think YouTube will have a problem with it, but it was for attempted sex trafficking. And what it was this guy attempted to set up a date with a minor lady of the night, shall we say, which happened to actually be a Mesa police officer undercover posing as a 15-year-old. So he got busted. He knew he was busted. Reached a plea deal for a Class C nonviolent, non-repeat felony. So Class C felony, 3.5 to 5 years. But he was out on bond because he was in street clothes. Like he came and he sat down like probably 4 or 5 chairs down from me in the waiting room, waiting for the courtroom to open up. And so he gets in there on this case, reaches a plea deal, and the judge asks all of the questions. Like, do you realize all of these rights that you're giving up by agreeing to a plea deal? And it was like, you give up the right to a jury trial. You give up a right to change your mind once you agree to it, unless you have good cause. Give up a right to testify on your behalf. You give up a right to not testify on your behalf. You give up all of these rights. And he read them like from memory. Like he's going bing, 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 bing. And I thought he was reading from like one of his computer monitors there, but he's like looking around. He's looking at the defendant. He's like looking left. He's looking right, like he does. We know Judge Beresky by now. He looks around while he's, going through these rote things. But he's just even keeled. He never raised his voice. There was one defendant that didn't show up, one of the like 8 that didn't show up. And his attorney's like, we'd ask for a continuance. And he just looks at her like, why would you want a continuance? He's supposed to make an appearance today. And at that point in time, he could have actually issued an arrest for this defendant that was out on bond. He didn't. He continued it. And actually right before, so she said, I called, he doesn't have a phone. I called his uncle. His uncle said he's coming to court today. He showed up like 10 minutes before Lori's case. And he goes, I'm here. I know I'm late, but I'm here. I had to go get my prescription filled. Like, that's a great excuse to miss a felony hearing. You were getting your prescription filled.
Dude, you hear all kinds of excuses when it comes to that.
Yeah. But it was just a really quiet day. I actually had, so when I first sat down, I sat down on the right side, which is beside the state side, which is where victims sit. And after like a couple of the cases, the state prosecutor comes over to me and he goes, are you a victim of any of these cases by any chance? I'm like, no, I'm not. I'm just here to observe. He's like, okay. And then later, Judge Beresky looks at me and he goes, are you observing for another court or something? And I was like, no. So that's how like intimate and personal that setting was. But then like 15 minutes before Lori's case, like the attorneys start coming in, Trina starts coming in, the media starts coming in, the social media starts coming in, like the gallery starts filling up, the court in front starts filling up. And there's like a buzz, like people are talking, and it was just a completely different atmosphere. And that was what was noticeable to me. So Judge Beresky is usually the same. That doesn't change. And the courtroom changed. And we actually saw Judge Beresky change a little bit today. At least I thought I did. Like I thought she got under his skin just a little bit today.
She probably did. I know how he feels.
So she comes in like right at 10 o'clock. He's not going to enter the court until she's in there. So she comes in at 10 o'clock. He comes in at 10:01. All rise for the judge. We all rise. We all sit down. And what's funny is if you remember sometimes, well, you may not remember because you were able to watch it on TV with microphones, but in that courtroom, sometimes you couldn't hear some of what Judge Beresky said.
I don't remember. I don't recall a time when I didn't hear what he said.
Like one of the most notable times that happened repeatedly is when she would go, all rise, and we'd all stand up, and he comes in the door, and like literally 2 seconds later, he says, you may be seated, or please be seated. And sometimes we didn't hear that.
Oh,
so
yeah. Well,
we're like,
yeah.
Do we stand up? Do we sit down?
Oh, yeah.
A lot of the other stuff we heard, but his voice is just so very quiet, and
right.
That's
like
probably
a soft-spoken
because
guy.
Yes, he's in a very small courtroom on a regular basis. So when he gets in that larger courtroom, he may not realize that it's a little harder to hear him in that larger courtroom, but it's just fine in the smaller courtroom. Like it's way smaller. It's a third of the size of courtroom D5.
Yeah.
All right. So the first thing they did, hey, Share Life, good to see you, Rita. Irish Amy, hey, Irish Amy's in here. Good to see you. So the first thing they did was they went through a bunch of motions that had been filed, and he heard from the state and he heard from Lori on a bunch of these motions. And the first part of it, they don't start getting worked up quite yet, but I want to go through like the paper ones real quick just to refresh your memory, because he went through them so fast in the court today. I was like trying to remember what were these motions that were filed. So I'm going to go in order. I'm just going to show them, read through them, not in their entirety, just real quick before we actually start watching the video, just so you guys can remember what the actual motions were that were filed. That they're getting ready to go through it. And I did them in order of what he did them in, just to help us all like keep track of them. Oh, here we go. So the first one they went over, got to reduce that just a little. That's too much. Was the motion for a new trial. What's interesting is this is the motion for a new trial for her 2021 case. Guess what? We're having a hearing today on the 2022 case. So I wonder the legal ramifications of that. Like, I'm a little bit curious if that's an issue to be discussing a motion on a 2021 case during a 2022 hearing. Just a thought. I'm not a legal expert. I didn't even sleep in a Holiday Inn Express last night. Shore Live, good to see you. Welcome in. Welcome in. Something to exclude the Jeep Wrangler, that's at the end, Rita, and we don't have that motion, but I'll talk about that again at the end. Let's go through these motions first so I don't get sidetracked like a lab on a squirrel. Memorandum of points, juror misconduct, preclusion of Tyler Ryan and Alex Cox's statements. So this is where Lori says, I need a new trial in that 21 case because there was juror misconduct, talking about juror number 15. They didn't let me put in Alex and Tylee's testimony. There was a discovery violation regarding the gray key data from the cell phone extraction. There was prosecutorial misconduct. The court's lack of impartiality, which we'll hear about later in this hearing. Court's lack of impartiality. Argument and authority. So here she cites some case law. She cites a lot of case law. Then she goes into details for some reason on juror 15. And then she talks more about the preclusion of Tylee and Alex's statements. She just goes into more detail about the statements she's already made, and she repeats herself a lot. Prosecutorial misconduct entitles the defendant to a new trial. And the judge commenting on the evidence during this defendant's cross-examination showed a lack of impartiality. So that's not the impartiality she mentions later, that she feels like she was wronged. All right, that's that one. So, boom. Then the next one that they will talk about is the state's notice of intent to use the defendant's other acts to establish conspiracy, premeditation, or motive pursuant to Rule 404B. So just remember, it's Rule 404B. They're saying if she goes, I want to read this more.
404B is usually bad acts.
Right.
Evidence.
Yeah, and that's what they're talking about. That's in order to establish motive, premeditation, or conspiracy. Talking about dark and zombie. The evidence that the defendant Chad Daybell and Alex Cox believed the victim was dark and or a zombie. Oh, so they're talking about the Idaho case is what they're talking about.
I was about to say it has to be. So what did that say? Yeah, you meant to send me that later so I can read it.
Yeah, we can read it now because I honestly didn't go into that deeply before. The defendant is charged with conspiracy to commit first-degree murder, a Class 1 dangerous offense that occurred on October 2nd, 2019. That's the attempted shooting of Brandon Boudreaux in Gilbert. The state will use cell phone records, iCloud accounts, and witness testimony to establish that the defendant believed that the victim was dark and or a zombie, that the defendant conspired with Alex Cox and Chad Daybell to kill the victim, and that this murder was premeditated. The evidence that the defendant, Chad Daybell and Alex Cox, believed the victim was dark and or a zombie will be used to prove the conspiracy, but is also relevant to establish the motive pursuant to Rule 404B. So, defendant's other acts. Let's read the first bit. The state of Arizona hereby provides notice that the state intends to use defendant's other acts as evidence of the conspiracy and or established premeditation. The state believes that this testimony and evidence is admissible. So has she testified that Brandon was dark? I'm confused about 404B.
Hang on.
I'll send it to you later.
Yeah, because they're talking about what her past acts. So I'll have to read that whole document and go look at
I gotta
stuff.
unravel this one. That one needs some unraveling for me.
Send it on over to me. Let me read it.
All right. So this one is a fun one. This one was like where I started to get the hint that she might be a little bit feisty today. State's request to preclude the media from showing the face of a testifying witness. And this is actually regarding Nick Balance. Nick Balance is on the state's witness list, and they do not want his face shown on TV.
Well, they didn't show it on TV during Chad's trial either. We had sketches. Now, they're not going to show Nick Balance on TV in Idaho for either then. Because Nick Balance is also the cell phone or the FBI cast guy in Idaho 4 case. He was also the same FBI agent that worked the Lori and Chad's cases.
So you'll find out, you're watching the thing that she's like, well, I don't have any objection to it, but, and she says some things that are just like, they cracked me up at the time, but I'm like, she's feeling a little feisty today. Like she's feeling a little underappreciated. She's like, I'm the pretty girl. You just need to take my word for it, and we can move on with all of these motions. So here's an amended request for a Rule 609 hearing. And 609 hearing is just, these are prior charges to be used. State of Arizona here. Let's expand that just a little bit so we can read that. Request that this court determine that the state can impeach the defendant with her prior convictions if the defendant chooses to testify. So the 404B and the 609 are two separate things that I was confusing in my mind. I'm starting to get them sorted out. So this is good for me. Sorry if it bores y'all, but her prior convictions, if the defendant chooses to testify, since the probative value of admitting this evidence outweighs its prejudicial effect. So yeah, they're just saying her prior convictions, and they actually filed this in the 2021 case, but guess what? Now they have some new convictions to add in there too. And this is if she gets up to testify, they can use those convictions to impeach her. Weren't you convicted of some prior bad things, lady? Yes, she was. But she has an interesting response to this too, that where she shows she doesn't know the law at all. All right. And then the next one is, this is regarding the Tammy Lachik. She's the Gilbert forensics officer that did some DNA testing on. So Kresha and I looked this up the other day, and it looks like Kresha did the Googling on it. Like Tammy did some DNA testing on parts of the Jeep. Like the Jeep drove down from Rexburg to take pot shots at Brandon, and then drove back up to Rexburg, and it was intercepted on the way back to Rexburg, and it was tested, and she flew up to Rexburg to either get some of the testing and take it, or get some of the samples and take it back to Arizona and have it tested here, is what it looks like to me. I mean, we're kind of speculating at this point, but that would make the most sense according to the research that Kresha did. So she's a forensics expert, especially dealing with like gunshot residue and DNA and all those like samples. So that's mentioned. And then we have two more that are mentioned before we can start watching the video. Handwritten motions by lawyer Lori. And somebody mentioned that last night when we were reviewing, was it this one? Motion for no restraints. No, it was the next one. The next one is the motion to meet with her. But this is the one that's mentioned next to last. In the hearing today, they discussed this motion for no restraints in trial. But the fact that she uses a capital R in Lori, maybe somebody that's a handwriting expert can read something from that.
Really?
Yes.
Is that her normal way of spelling her name?
It is. Like I couldn't unsee it after they said that. I was looking through both of these handwritten motions, and I'm like, she spells Lori with a capital R every single time.
That might be just her thing. I've got a quirky few things on my writing, but that don't make me, deranged. I'm just saying, I don't know if I'll read anything to it or not.
Right. And I'm not saying that they said it makes her deranged. I'm saying it maybe.
No, I get what you're saying. You wanted to see what somebody thought about her personality because of the way she wrote that.
Right.
Right.
And look at her capital.
I get it.
Look at her capital E in restraints.
I write my E's like that sometimes. It depends on my
mood.
Do you
really?
It can change. Dude, my handwriting can change from day to day. I am not joking.
Oh, you should see my notes. You should see my court and hearing notes. Like, you would think, looking at the different versions of notes that I make in court, that I may be like bipolar, or I may be schizophrenic because they look so different. And today was horrible because the back and forth between her and the judge was just so fast that I could not keep up. It's like the sloppiest notes I've ever taken. Literally the sloppiest notes I've ever taken. But luckily it was recorded. Even though the audio sucks, the video was recorded. And we have the audio for whatever it's worth. Okay, motion for no restraints in trial. And I hadn't seen this before today. I didn't even know it existed. When the judge mentioned it, I'm like, as soon as I get home, I'm going to look this up. And lo and behold, there it was on the docket. Request that all restraints be removed, be waived for this defendant during trial. The request is made pursuant to blah, 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 blah. On March 20th, the Maricopa County Sheriff's Office filed a response to the defendant's request regarding restraints. She claims that in their Exhibit 1 to that response, there's a letter there, THEIR. Lori. There was a letter from the sheriff's office, Lieutenant Christopher Houck. In this letter, Lieutenant Houck states, I base my decisions on the totality of the circumstances, including without limitation, current charges, past convictions, past charges of custodial disciplinary history. Due to inmate behavior, after looking at all of the previous areas of concern, I have determined that the minimum recommendations previously stated are in the best interest of courtroom security. The rack belt was utilized in the last trial. It was able to be seen while under clothing. So now we know. She took a little break one time when she was up cross-examining one of the witnesses, and she said, Your Honor, can I have like a 5-minute break? And I thought it was a bathroom break at the time. Come to find out today, and through this document, which I found when I got home, a part of her rack belt had slipped out underneath her jacket and was showing underneath her jacket. And she's like, Your Honor, I need a break. She goes and she tucks it back in, and she comes back out 5 minutes later. So it wasn't a bathroom break as I thought it was, but she did that in a hurry, and he granted it. He let her go do that. As it slides out 4 inches from the defendant's back. Really? Did you measure it, Lori? One of the problems is that it is a one-size-fits-all and is made to accommodate larger men. Maricopa County Sheriff's Office does not have a belt designed for the size of this defendant. I'm way sexier than those other men that wear the rack belt. Wow, her handwriting. There were many issues with defendant, something trying to fit this belt on defendant, as well as difficulty taking it off because it had to be wrapped around the defendant so many times. In theory, the belt is not a bad idea, but in practicality, it does not work. Therefore, this defendant requests that an armed sheriff's deputy be in the courtroom instead of the rack belt, as recommended by the Maricopa County Sheriff's Office in the last sentence of their response dated March 20th. That's interesting. I hadn't read that till just now. So you're getting my live reaction. Per the jury interview, they could not see the belt. She's going to talk about that today, Akasha, in the interview, but she wants something more than an interview. And she discusses that in the hearing today. Did I miss anything good? Prior bad acts. Okay. 404B 609. We're going to get it all sorted out. Judge is going to sort out one of them today and not the other one. They don't have Tiny got his side. Oh, right, Salty. Yeah, she started leaning over on that right arm to kind of hide it from the jury. Oh, there you are. You disappeared.
Well, I figured you'd realize it eventually. I hit a button by accident and fell right out of there. I did.
Well,
I'm like, oh no, I fell out.
The portal spun you around and spit
It
you right
did.
back in. You know?
It got me. It got me. So you think she's just tired of standing crooked, trying to get that belt to stay in place?
Yeah, because I mean, she's got to feel good about herself by having to have a belt wrapped around her twice, because she's like, look how skinny and fit I am. I'm just a tiny little woman.
Oh wow, women! I guess women think about that kind of stuff. That wouldn't have been my first thought, but okay.
She's
this darn thing's
accessorizing.
uncomfortable. Y'all could shot me by accident any minute. All these.
Right.
My thought process and women's is different. I know that, but it's funny.
What if that managed to cause her to shock herself, like double wrapping up around herself? Like,
oh no, there were a few times we were waiting on you to jump up and grab the buzzer and like, just zap her, Joe. Just get her one time for us.
I was looking for it today. I was looking for whoever was holding that remote.
Joe's like, give it up. I want it. That's funny.
I think between Kresha and Megan and you, I think we could probably raise bail money, right?
Of course. We got this. We'll crowdfund if we have to.
Start a GoFundMe for Joe's for Joe's bail money.
Joe's bail funding. He took out Lori.
At least got a couple good shocks in there. Motion for time to consult with advisory counsel. I posted this on Twitter. They discussed it today. It was the last thing they discussed today. And it actually comes up twice in one form or another. And it's very interesting. The second time it comes up, judge is getting a little snarky with her about this. She complains that she did not have access to her team. She calls it a team, which is her advisory counsel, even though she's lead counsel, and her paralegal and her investigator in the first trial during breaks. I want to see exactly what she says, because the judge kind of takes issue a little bit with her claiming that.
Yeah, because I'm a little curious, because in all honesty, most clients do have that access. She's no different as far as once we get to court. And I know how everybody feels about her, but I can't hear the way I look at these court cases. I can't say it's okay to not allow her that, but you better allow another defendant that, right? So he's
Right.
going to rule within the law, and I expect him to.
She says there were several instances in the last trial where, because she says several instances. She doesn't say all the time. I read it when I first read it. I read like all the time, but no, she says several instances. So I think if it had been every time, she would have said every time or not ever allowed type of thing. So, but she says there were several instances in the last trial where, because of the detention officer's schedule, as well as the court schedule, that this defendant was denied access to consult with her defense team. That is a due process violation. This defendant is requesting that the court schedule time for defendant to meet with her team daily at the lunch break and both morning and afternoon recesses. Well, we didn't have morning recesses because we didn't start till 10:30. So, but anyway, it can be in the attorney legal room, which is right next to the public seating area and the media seating waiting area. So that's probably not a good idea. Like literally media 3 to 4 to 5 feet away from that door, and the public not much further away. Or the courtroom, or wherever this court deems necessary for security purposes. Thank you. All right, so that's the last one of those. Now that gives you a little refresher. Oh, Shore Life, thank you. All right, Shore Life is starting my bail fund.
Mm-hmm. You got one ahead of that one too, I thought.
Do we? Oh, yeah, we do. Look at librarians. Mm-hmm. Oh, no. She doesn't say it specifically for the bail fund, but we'll probably have to.
You can, yeah, you can add it to it if you need to.
Thank you, librarians. I appreciate it. That's very generous. Oh, goodness gracious. Now we can get to the actual video. Now that we have a background of all of the motions they're going to discuss. Salty, have you seen this video yet, or portions of it?
Of what? The trial?
The hearing today.
No, I haven't had time. We were streaming until 3:00 with the Karen Reed, and I knew you were going live shortly after with the hearing, so I didn't. I just saw a few blurbs on Twitter and read your Twitter, and that was it. So I haven't even had time to review this hearing at all. I just know there was some spicy stuff happening.
All right, here we go. We're going to dip into the spicy. And just so you know, the hearings or the motions that we just read through take up like the first 11 minutes of this, and the audio is crappy. So apparently Court TV and Fox 10 teamed up on this today. Court TV came in with the broadcast electronics, and then Fox 10 came in with camera, and Fox 10 got there kind of late. Fox 10 didn't get there with the camera till I think it was 20 till 10. And 20 minutes to set up that camera in that courtroom is pushing it. And they were having trouble with some of the cables. Apparently, one of the cables they were having trouble with was the audio cable. So the first few minutes of this, the audio also sucks. So I'm going to listen to it. You're going to have to like adjust. I did the best I can to turn the volume up because it's low at first, and I think I'm going to have to dial it back down as we get further into it because the audio levels and quality changes throughout. Her microphone sucks the whole time.
For the record, I believe the victim is appearing virtually.
Lori Daybell.
All right.
So, by the way, that the victim is appearing virtually, that must be a carryover from the prior and it's like way before. So I don't know how that got put in there, but that very last case that was heard before Lori's ended like 20 minutes before. So I don't know how it got carried over, but yes, the victim's made an appearance in that case, and that victim appears virtually, has nothing to do with Lori's case. It was the prior case before that. Somehow it got picked up and recorded by their equipment.
We have a number of things to discuss and get through here today. First of all is the motion for new trial the defendant filed. I received the response. I think the reply is due today. Is that being filed?
Yes, Your Honor, I have it right here. And
Is it ready to be filed?
yes,
Okay, we'll file that. You have a copy for the state?
I do.
Okay.
So we actually read through her motion for a new trial. We didn't read through the state's response to the motion for a new trial. It's kind of lengthy. It's Trina's usually good stuff where she just goes through point by point, makes some good points.
I've read it
No,
on my channel. I thought you read it
Yeah.
over here, didn't you?
I think I did.
Yeah,
I think
you
we
did.
went through that. Yeah.
Mm-hmm.
So now Lori's response to that response to her motion is due today, and she has it ready to go, but apparently her glasses are a little bit dirty.
The response, I'll take a look, or the reply, I should say, I'll take a look at that. The next thing I wanted to discuss was the state had filed a notice of its intent to use defendant's other acts to establish conspiracy, premeditation, and or establish motive pursuant to Rule 404B. In your pretrial statement, you indicated you wish to strike or withdraw that?
Correct, Your Honor.
Okay, so that's withdrawn. Next, we have state's request to preclude the media from showing the face of a testifying witness, one of the witnesses. I'm assuming you don't really have a dog in that fight, Ms. Daybell? Or do you have a response?
I don't have a dog in the fight, but
I don't, but I have.
Did they withdraw a motion? Did we just hear them say they withdrew a motion they submitted?
Yes.
Because I'm trying to pay attention to that. And which one was that to bring in the
six? That was the second one. That was the six or the 404B. 404B is the one that.
Yeah, because it's hard to get that admitted to start with. It depends. So the fact that they withdrew it says a lot to me. They're not going to use that 404B evidence then. If the state withdrew their motion.
State's request to preclude the media from showing the face of a testifying witness, one of the witnesses.
Did we
take a
jump too
look,
far
or the reply, I should say. I'll take a look at that. The next thing I wanted to discuss was the state had filed a notice of its intent to use defendant's other acts to establish conspiracy, premeditation, and or establish motive pursuant to Rule 404B. In your pretrial statement, you indicated you wish to strike or withdraw that?
Correct, Your Honor.
Okay, so that's withdrawn. Next, we have state's request to preclude the media from showing the face of a testifying witness, one of the witnesses. I'm assuming you don't really have a dog in that fight, Ms. Daybell? Or do you have a response?
I don't have a dog in the fight, but I haven't had a chance to read over. I just got a bunch of this stuff, so I'm not really sure what they're asking for.
Well, one of the witnesses also works in an undercover capacity, and showing that witness's face could compromise other investigations or things that that witness is doing. So it's a request to not broadcast his face through the media out into the public.
And is this witness FBI or something to that effect?
It's Nicholas Balance.
She knows who he is.
Yep.
I think he is an FBI agent.
Correct, he is an FBI agent.
And he's a relevant witness because of why?
You want me to tell you why?
You go for it.
They found your
knows.
kids in the backyard at Chad's house. Thanks to their FBI cast abilities, Lori. That's who that is.
I wonder if he did any checking of cell phone data related to the attempt on Brandon's life.
I'm not sure how, I haven't read any of Brandon's documents, but I know all about Nick Balance and all his testimony in Lori and Chad. I've went and aired his entire testimony in Chad's before, because he's the guy going up against Cyree in Idaho, and he's damn good at his job.
Mm.
He's really
Well-
good, well-spoken. You can understand everything he's saying. He articulates the cast stuff really well to understandable terms. The drive time test, all the things he's going to talk about. It's beautiful. It's a beautiful testimony. I can just say that.
Somebody said he's pretty good looking too.
Well, he is. From the sketches we saw, we didn't get to see his face in Chad's either, because he is FBI.
I'll get to see it.
Sometimes-
I'll get to
Yeah,
I'll get to
sometimes
see
you
it.
can. Yeah, sometimes you can see them. It depends on the agents. You know what they do. They'll show some FBI agents, but most of the time they don't show them. You'll just get a sketch, which is weird. Also,
Yeah, she knows.
she
But
knows who
okay,
he
so
is.
one of the points I was going to make that you took me down was, so the Gilbert PD cooperated with the Rexburg PD, and kind of cooperated with the Chandler PD also. So I'm wondering if when there was a cell phone extraction done, if they're like, okay, we've got this stuff going on in Idaho, but hey, look, we found this cell phone location data for all the way down in Gilbert, Arizona. What was going on with that? Oh, wait, somebody was shot at down there. Like, I wonder, because that Tammy Lachik gal, Kresha pulled up a report the other day that said that she flew up with maybe even a couple of times with other police officers, detectives type of people up to Rexburg to get evidence from them and bring it back. So I'm wondering if some of that cooperative overlapping evidence also was like what Nick Balance came up with.
Well, whatever Nick's going to bring is going to be tied to FBI cast stuff. Right? So is there something on the phone data they found in Idaho that ties to these? And they will absolutely work with one another. They should, so it's got to be something to do with FBI cast, which is the phone data guy.
According to the state's notice, he created a PowerPoint regarding some of the Wi-Fi or cellular data
Cellular and
location.
Wi-Fi use, yes.
Mm-hmm.
I have no real objection to him being obscured. I don't know how they'll do it, but
All right, so I'll direct the media during trial when witness Nicholas Balance is.
Wait, I don't know how they'll do it. You don't worry your pretty little head about it. How they'll do it. That's you have nothing to do with the media not showing his face. Like nothing.
That's just
I don't know
Lori
how to-
expressing her views. She can't help herself. She can't.
Is called to testify. They can't broadcast his face out. They can focus the lower part of the witness stand or something like that, but his likeness or image or face should not be broadcast out to the public. So I'm essentially granting the state's request in that regard. Next, we have state's amended request for Rule 609 hearing and the defendant's response. When I read the amended request, you're simply adding the most recent conviction, correct?
Yeah.
You didn't really respond to that in your reply. You kind of just talked about the previous reply that you had made about, did you notice that she had asked to basically add your most recent conviction?
I saw that, but I didn't know what the law was since I wasn't sentenced for that yet. So I wasn't quite sure where to.
Okay, that's not what that means. Sentencing has nothing to do with convictions in a 609, right? Like 609 is about using prior convictions. So what they did was they amended their prior 609 filing that talked about her prior convictions in Idaho. And now they can add in, they can amend that to add her convictions in the 2021 case against Charles. So just listen to her once again. She goes, I haven't been sentenced at that yet. So I don't know what the law is. Well, yeah, we know you don't know what the law is, but.
Well, remember, she didn't want sentencing till after Brandon's case.
Yep. She could have been sentenced by the end of the month before the case. That could have happened. But she did not want it.
Conviction, correct?
Yeah.
You didn't really respond to that in your reply. You kind of just talked about the previous reply that you had made about, did you notice that she had asked to basically add your most recent conviction?
I saw that, but I didn't know what the law was since I wasn't sentenced for that yet. So I wasn't quite sure where to go on that. So I left it off.
Okay. With the 609, I think similar to the last trial, I'll put that off. And depending on if you testify or not, it only really becomes relevant if you decide to testify. So we'll table that for the time being. Next, I have the state's motion limiting to preclude inadmissible evidence relating to Tammy Latchik, who is a evidence scene technician type person from the, I think it's city of Chandler.
We looked her up on the channel when that motion first came out and realized who she was and what she did.
Okay. Well, you can tell that Judge Beresky doesn't watch true crime because he didn't use her correct title. He said she's like an evidence scene technician type of person.
Mm-hmm.
I'm like, he does not watch true crime. He gets in his convertible and he goes home and he pours 2 fingers of bourbon. He's like, God, that woman drove me nuts today.
Lord, I wouldn't let her drive me to drinking, but darn, you might need have to.
She drove him to raise his voice today. She did, and it was completely unlike him. I'm already tainting the jury pool. Like, I'll let you form your own opinion, but to me, it was not Judge Beresky. Like a couple of times, and it was not like in any way out of bounds. Like it was just like, to me, anyway, we'll get there. We'll get there soon.
And it's probably not the first time he's had to get stern with defendants in the courtroom or attorneys for that matter. You know, look at the way Judge Hippler does.
Gilbert, did you have a chance to review that?
I just got it and I am in the middle of responding to that. But I do have a request in that regard.
She needs to follow me on Twitter so she can get these documents when they first drop, because that's where it's at. Like I beat Justin to the punch like 8 times out of 10 now. But he got me the other day. He got to it first.
Which is?
From the state. Since it was, just given to us, and I'm sure that the state had that information clearly before now. We need additional information, and due to that late disclosure, I was going to ask the state if they could disclose to us the employment records of Tammy and the emails regarding this incident and any recordings or body cam videos, so that we don't have to have my investigator try to do an investigation so quickly. If they have that information, if it could be turned over to the defense so that we don't have to try to gather that.
This is a weird one right here. It's complicated and full of layers, so I want to listen to it again. But she's complaining that she didn't get evidence that she needed to follow up on until like the beginning of May, and so she hasn't prepared her response yet. So she's got an excuse, and I'm trying to figure out if I think it's a valid excuse or not.
Did you have a chance to review that?
I just got it and I am in the middle of responding to that. But I do have a request in that regard
Which is,
from the state. Since it was, just given to us, and I'm sure that the state had that information clearly before now, we need additional information. And due to that late disclosure, I was going to ask the state if they could disclose to us the employment records of Tammy and the emails regarding this incident.
I need to know what late disclosure is, because I thought I remembered the date of the disclosure being like May 3rd, which would be exactly 30 days before trial. So that's technically not late, but I may be thinking about that with a different case. So I need to rewind like 45 seconds.
limiting to preclude inadmissible evidence relating to Tammy Latchik, who is a evidence scene technician type person from the, I think it's city of Chandler. Gilbert. Did you have a chance to review that?
I just got it and I am in the middle of responding to that. But I do have a request in that regard.
Which is? From
the state. Since it was, just given to us, and I'm sure that the state had that information clearly before now, we need additional information. And due to that late disclosure, I was going to ask the state if they could disclose to us the employment records of Tammy and the emails regarding this incident and any recordings or body cam videos, so that we don't have to have my investigator try to do an investigation so quickly. If they have that information, if it could be turned over to the defense so that we don't have to try to gather that information so quickly.
Well, I don't think you're necessarily entitled to all those things if it's deemed that incident is irrelevant to her testimony. So I think the threshold issue is if you want to file a response where you think that is relevant, something that you can get into an incident that happened 4 years later, I guess when can you file your response?
I kind of have a problem with him stating that. If you can get into an incident that happened 4 years later, that's kind of all of this. The state's getting into an incident that happened 4 years later. And granted, we all believe very strongly that she's guilty of this conspiracy, but just raising the issue that an incident happened 4 years ago is irrelevant in this case.
Mm-hmm.
Like she does deserve the right, and she says we just got this, so I wonder what that means. Like, has the state been
right? What date did she get it compared to what date it was due by? Things like that, because when you say things like you just said, I don't want people to come and think we're like, oh, all for Lori, but it matters, because if we want justice with the victims, it all has to go down the right way, even if it's Lori. Don't let nothing come back to get her on appeal later. So yeah, I get you.
No juror issues, no evidence issues, no procedure issues, no discovery issues.
Yes.
Let it all play out in court.
Yep.
Without any further information, I don't know, when is that response necessarily due, Your Honor?
It was filed May 3rd, so technically it's already past due.
See, okay, he just said it was filed May 2nd or 3rd, so it's past due.
Your Honor.
It was filed May 3rd, so technically it's already past due. So can you file it by next, you have a copy of it now?
I just got a copy, correct.
Right.
Was she like jiggling her foot, like in a nervous way, like bouncing her leg? Like, I know people that do that, like when they're nervous, they'll bounce their leg, but I don't think I've ever seen her do that before. Watch this.
3rd, so technically it's already past.
Look at that. Yeah, she is. She's shaking, and I think it's because she's like tapping her foot or something.
Next, you have a copy of it now?
I just got a copy, correct.
Right. How about next Wednesday?
Okay, chat, do you guys see that too? Oh, she's getting pissed off. She's like trying to contain herself. That would make sense. Like, I know people that are either nervous or they're pissed off. Yeah, I can see that either way.
From like tapping her leg or moving her leg a lot.
Yeah, what like I haven't seen it on this HD
I
yet.
do it
It's
for
like on
different.
my
I do it for various reasons. Sometimes I'm mad. Sometimes I'm anxious. Sometimes I'm bored. I do it at random times for random reasons.
I have not noticed
real.
her doing. Yeah, I have not noticed her doing it before, so it's noteworthy to me just because I
They
haven't
showed
seen her doing it.
one time when we were watching trial, they would show her feet. Well, it was some of the hearings too, but her foot would go a lot sometimes, but not like her whole leg. You know what I mean? So I don't know.
Right.
I haven't studied Lori's body language enough to even worry
Third, so
about it.
second, technically it's already past due. So can you file it by next, you have a copy of it now,
I just got a copy, correct.
right? How about next Wednesday, the 21st?
Yes, I can do that.
All right, so we'll set
And I have
that
a
aside.
question on that as well. Can I make an objection on the sealing? Can I ask under what law or rule or statute that this motion was sealed under?
She's really shaking. She's really like
They've
doing
requested to
something.
file it under seal because of the nature of the motion and the contents of what that incident is, not needing to necessarily be in the public eye. So if you want to include in your motion an objection to it being filed under seal, you can do that as well.
Okay,
So you'll file that no later than May 21st. I don't need a reply on that. I'll deal with that, I guess, probably our first day of trial or so.
so you're not going to set a 609 hearing?
This is not a,
Oh, not the 609, but a hearing for Tammy Lachik?
I can listen to oral argument when you filed your reply, but I don't believe I needed any sort of hearing on it. So I'll deal with that May 29th or 30th, I suppose. All right, then we have the defendant's motion for no restraints in trial dated May 6th. I don't know, in your motion, I don't know where you get the idea that the sheriff's office recommendation ever was that you have no restraints at all. Their minimum recommendation was that you wear a rack belt.
Well, I have it right here and I copied it verbatim.
Yeah, you
Okay,
said, what it said was my recommended minimum requirements as listed above, and those were to wear a rack belt.
It said, or the recommendation of MCSO was that they could have a unarmed detention officer and an armed deputy sheriff if I was to not have any restraints.
Right, but that wasn't their recommendation. I've received the defendant's motion. I've received non-party Maricopa County Sheriff Jerry Sheridan's response.
On the MCSO security justifications, my understanding is that was his recommendation.
Your Honor, Joseph V. Hill for the Sheriff's Office, if you have any questions.
Oh, okay. Well, I'll deny the motion from the defendant. The same conditions will be set that we had in the first trial, that being you wear the rack belt, no leg brace. There was one incident during the trial where you asked to take a break because a strap was hanging down behind your jacket. We did that. We rectified the situation. There's been no indication whatsoever that the jury.
This is a good point right here because this is a failure of lawyer Lori once again, because if she felt like that belt showing behind her suit coat or her blazer, whatever you want to call it, affected the jury, she had a responsibility to act upon that in a certain way. And the judge is going to point it out to her. You missed this, gal. Salty, you keep disappearing on me. I hear that little bloop. I'm like,
I
where'd she
went to
go?
close chat and I hit the back button by accident twice now. I'll try to refrain.
So listen to what the judge says she should have done if she felt like that her rack belt coming out of the back of her jacket affected the jury.
Notice the rack belt or anything like that. So I think those conditions are appropriate and will remain for the second trial.
Your Honor, the jury was not polled to see if they noticed anything either. Was that correct?
Right. There was no request for that.
There was no request to poll the jury. Oh, what is she doing with her hands here? As soon as he says that, she's doing something with her hands. Okay, something else I wanted to point out that I forgot to early on. So when I hung around court for an hour and a half before her hearing today, and I was watching the other hearings, there were several prisoners that were brought over on felony charges from Maricopa County Jail. They were also wearing the orange, like plain orange shirts for the gentlemen, orange jumpsuits for the ladies. Every single one of the other defendants had a dirty, filthy orange shirt or jumpsuit on. Look at how pristine, like she's wearing an almost brand new orange jumpsuit. Like it looks like it came straight out of the package from wherever the county jail orders theirs. This has not been worn by anybody before she wore it. And I'm just like, how did she rate that? Like, did she berate one of the jail employees and be like, I can't wear that. I can't wear that. I can't wear that.
No, I mean, even her assistant attorneys can help her with stuff like that. But a lot of the county jails, they have their laundry that comes in a couple times a week. I don't know what to tell you about where she got her suit. I don't know. She's gonna get to wear a real one in the real courtroom, but at least it wasn't looking like Rick Allen's.
Right. No.
I mean,
And most prisoners don't get a brand new jumpsuit to wear to court. I mean, but somebody has to, right? I mean, the jumpsuits are brand new at one point or time. She just got one to wear to court today for some unknown reason. And it was noticeable to me in the courtroom after seeing the other defendants come in like dirty, nasty shirts,
were they men?
jail garb.
Were they all men?
I think there were 2 men and 1 woman, if I remember right. I think the second one was a woman in a dirty orange jumpsuit.
Well, they might be like Stearns and refusing showers and to change. I don't know.
Yeah. Anyway, that was an observation from me in court today, and having attended the previous hour and a half. I don't know one way or the other how she got it.
All right. So next we have defendant's motion.
Wait, did you just see that? What was that little smile? People were asking me about that over in Crash's chat. Like, who is she smiling at, smirking at right here? Watch this look she gives.
Right. There was no request for that. All right. So next we have defendant's motion to consult.
She gave a little smile as she's turning her head back to the right. So don't know what's going on, but the people that are seated there to her left are her advisory council. That's Pam Hicks and whatever his name is, Abernathy. Is it John Abernathy, maybe?
Yeah.
I don't remember.
Was there a good chance she was looking at them and just flashed a little smile? If they were sitting there to the left? I know, but you said they're sitting to her left and she looked to her left. So I was just curious that's who she was looking at, was her attorney's team.
That's what I assume. Yes, that's what I assume, because the only other guy to her left is the jail security officer that escorts her in and out of jail. So she wasn't giving that look to him, I guarantee.
Right.
So yeah, it was one of them or both of them.
Consult with advisory council and team during trial dated May 6th. I don't know I guess what exactly are you requesting? Are you requesting that during the lunch recesses, you be housed somewhere where you can meet with your team?
Correct.
Okay.
And I know that it's a DO situation, and I know that our DO has his other obligations to do. So I didn't know if another officer could if something could be arranged so that I would have time with my team during those breaks and during lunchtime.
We did accommodate that during breaks and recesses during the trial, to the extent that it doesn't delay the jury getting into the courtroom and resuming the trial when we need to, like when we take the 15-minute afternoon recess. That will continue. You'll have an opportunity to meet with them briefly. Over the lunch hour, I think is the real question. I did receive a response this morning from the sheriff's office, which indicates they don't really have an objection to that. Is that correct?
That's correct, Your Honor. There is an area on the 4th floor in the South Court Tower where she can be taken to meet with her advisory council, and they'll work that out.
All right. I don't have a problem with that. So if you need to meet with them when we break for lunch, just indicate to the DO that's what you need to do. There may be a day where you don't need to meet with them, but I'll essentially grant. Ms. Kay, I don't assume you have an issue with that.
I have no position on it.
So I'll grant the defendant's motion on that she can meet during the lunch hour. Again, the only restriction on that is that we're not going to delay bringing in the jury at 1:30. We'll expect everyone back in the courtroom to start on time. All right, let's talk about.
So the defense team has that room that's right next to where the public and the media sit. And where we wondered at multiple times during the trial if Lori was in there. But when you're sitting in the courtroom, she goes out the left door, and that defense team room would be to the right door. So they were on opposite sides of the courtroom for most of the breaks. Like she'd go out the left door. Well, everybody stands up, the jury files out. Takes like a minute for the jury to file out. And the defense team goes out the back door off to the right. She goes out the left door. Who knows where does she sit in a room? Does she get lunch? I don't know. Probably whatever they feed her lunch. But they're on opposite sides of the courtroom for those breaks. So what the Maricopa County Sheriff's Office representative just said was, well, somewhere in one of those back rooms in the South Tower, we can put them all to meet during the lunch break. But that means that her defense team does not get a true lunch break. Like they have to take their food and they have to go to whatever room the sheriff's office says they're going to meet in. And they have to sit there and eat their lunch while she's consulting with them. Like it's, and they're not, they're not getting paid crap. Like I would think they're not.
Do you think Karen Reed's sitting with her attorneys at lunch?
Right, but she's free on bond, whereas
I understand. That's not what I get it.
Okay.
I don't know when they, did they go to the jail and have regular meetings with her? I don't know all of that because I haven't looked at that. But she still, if she's being denied access, which I don't think she is, then of course she needs it. But I don't know. A lot of this stuff on this case, I'm gonna stay quiet on.
Yeah, I think she deserves the right to consult with counsel on breaks. But I also think it sucks for her public defender co-counsel or advisory counsel to have to do that. But I sat in the gallery, I sat in the public waiting room and didn't eat lunch a couple times, which is not.
They're
comparable.
grown-ups, Joe. They're grown-ups. They'll be okay.
Right. Maybe they can eat some gummy bears
Or a sandwich real quick. I don't know.
I think she's planning an escape. Just me.
And she might be. You never know.
I've seen a defendant escape from that type of trial detention, and he was pretty sneaky, but he basically only made it to the front security guards and he was done. So Yeah. She'd have to find something to do with that orange jumpsuit if she wants to escape, and the rack belt underneath that.
Yeah.
All right.
The trial schedule and the screening. I received in the state's pretrial statement. Have you seen that?
I just did, yes.
Your Honor, may I be
Yes,
excused?
go ahead. Thank you. The state's pretrial statement indicate there was some witness scheduling issues. If we get the jury sat on the 30th and impaneled on the 30th, the last Friday in May, and we have our opening statements and begin testimony and evidence Monday, June 2nd, you indicated that the state indicated you would run out of witnesses either Wednesday or sometime Thursday.
Correct. That are available that week, yes.
Right. And then so we'll definitely go dark.
She does that thing with her hands, like she did that in the first trial. And I know it's not nerves. I know she's not nervous. It fascinates me. Like doing that thing with her hands. I got to back up and watch it again.
Run out of
Talks with
witnesses
her
either
hands.
Wednesday or sometime Thursday.
Correct. That are available that week, yes.
Right. And then so we'll definitely go dark on Friday the 6th. I had initially indicated we would be in trial on that day, but if we can't have any witnesses here, we'll be dark on that day, and we'll indicate that for screening purposes for the jurors.
So just to recap, jury questionnaires are going to go out the last week of May, and they're going to have jury selection the 29th and 30th. Well, they'll go through the questionnaires on the 29th, seat a jury according to Judge Beresky, and one day on May 30th. Was I saying May? I hope I was saying May. May 30th. June 2nd, opening arguments. And Ms. Trina Kay just said, I have 3 days worth of witnesses, and my other 3 witnesses can't testify the end of the first week of June. They're not available for the 5th or 6th. So the judge said, okay, well, maybe your first few witnesses will go into the 5th. So we'll leave that open on the calendar and we'll play the 5th by ear. If we're ready to conclude for the week on the 4th, we'll conclude for the week on the 4th. 5th and 6th. 5th is in or out. 6th is out. 6th is going to be dark. The following Monday is June 9th. And as Kresha reminded me earlier, that's the day that they found Tylee and JJ on Chad's property in Idaho, was June 9th. Heavy stuff. So the last 3 witnesses that can't come the first week of June will testify on June the 9th, Monday, June 9th. And then
A Monday.
Yes.
That's my darn birthday, man.
June 9th?
Yeah.
Oh, wow.
It's always been June 9th. Kaylee Gonzalez is June 8th.
Since the day you were born. It was June 9th since the day you were born?
Yeah, and it's been a big date in Lori's case for a long time.
Yes. Yep. So Lori's case will probably start on June 10th, and she may do the thing where she did in the prior trial, where she says, I have no witnesses and I have no evidence and I'm not going to testify. And then they start closing arguments. That could start June 10th. If she does manage to get in any witnesses or evidence, I can't see it going more than a couple of days. And June 13th, Friday the 13th, should be the last day. It's got to be the last day. Because she has not followed the rules of the court, the rules of procedure. That's what it is, in getting all of these witnesses to the state to interview in enough time to present them in trial. Rachel, maybe that local reporter will be me. I've got a 1 in a million shot. So you're saying there's a chance. I did apply through the proper guidelines, but it is like a 1 in a million shot. Original rules of procedure and evidence. There you go. She knows nothing about those. All right. So let's keep going with this.
I think we'll still indicate that we'll be in trial on the 5th, and we'll have to play that by ear. Maybe we will be dark, maybe we won't. But as far as when you resume on the 9th.
Wait, did he just say that to Lori? He just said, maybe we'll be dark, maybe we won't. And she's sitting up there staring at him saying, dude, you're dark. Dude, you're dark. And we haven't heard anything yet. But that's just so funny that he says, maybe we'll be dark, maybe we won't on the 5th. How appropriate.
You said you thought you would have 3 witnesses left at that point?
Correct.
Do you have an anticipation? Are those witnesses that would each take a whole day, or?
I think it's possible I could finish that day.
So ultimately what I'm getting at is trying to drill down the schedule and screening for the jury. Do we not need to screen them for the week of the 23rd?
Obviously, I just received the defendant's 15.2 that lists 2 different expert witnesses. I did request that they actually comply with Rule 15.2 and give me any information about any of these experts. They've also listed other witnesses. So because of that, I would still screen them for the other week.
Well, maybe we should address that. Is there still no report from Lonnie Dworkin that the state's received?
I have received nothing.
Wait, how long has she had Lonnie Dworkin working on this case?
Dude,
that's
a mess right there.
It was back from the beginning of the first trial, like back in February, I think February 7th, he started working, or she got notice that he could start working. No, it was March 7th. It was March 7th.
Yeah.
That she got approval, but still March, April, May, it's 2 months later and she doesn't have a report to give to the state. Maybe he did prepare a report and she just doesn't like it. Maybe.
Maybe.
Do you have some sort of expert report you were disclosing?
We will, Your Honor, yes.
When?
Oh,
We will. She doesn't say, I have a report, I just haven't filed it yet. We will have one. 2 months after he started working on it. Yeah.
But has he turned over a complete report to her yet? That I don't know.
when is that going to be? Because it's way past due.
So the state did receive the affidavit from Lonnie explaining the things, which is why they turned over late discovery.
The state received an affidavit. They didn't receive a report. They received an affidavit.
And then she was about to say something else behind all that. So let's see what she says about it.
All righty. I'm going to back up just a couple seconds so we can hear the whole thing.
I have received nothing.
Do you have some sort of expert report you were disclosing?
We will, Your Honor, yes.
When?
Well, when is that going to be? Because it's way past due.
So the state did receive the affidavit from Lonnie explaining the things, which is why they turned over late discovery in the middle of trial. So we did have that. He's working on a few things for us as well now, and I will get with him as soon as possible and get that report to you as soon as possible.
All right. Well,
As soon as possible, Joe. She's going to get it as soon as possible.
I will get with him as soon as possible, and we'll get you that report as soon as possible. Just to hear how her voice went up at the end of that.
Yeah. That's crazy, Lori.
Meek, mild Lori.
I don't think soon as possible is going to be good enough.
The state did receive the affidavit from Lonnie explaining the things, which is why they turned over late discovery in the middle of trial. So we did have that. he's working on a few things for us as well now, and I will get with him as soon as possible and get that report to you as soon as possible.
All right, well,
Possible.
it's, depending on what's in that report, it is likely to be precluded at this point, but I'll keep an open mind on that, and I guess we'll wait and see. Let's talk about, for the purposes of scheduling.
Your Honor, and just, there's one other person that I'm Googled.
I'm going to ask her about the other
Okay.
witnesses. I received your supplemental witness list, I think yesterday. You have, in addition to Mr. Dorkin, you have Weaver, Barkman, again, Detective Moffett, Jeffrey White, Melanie Gibb, and Zulema Pastanas.
Oh boy.
Mm-hmm.
I sat up in my chair right that moment. I was like, what?
I knew she'd asked
What?
for this, but yeah.
And we're going to have a further discussion about that in a couple minutes. That's part of the reason for getting heated.
Again, Detective Moffett, Jeffrey White, Melanie Gibb, and Zulema Pastanas.
Zulema Pastanas.
Okay. Was Detective Moffett also involved in this case?
He was involved with the case agent of this case while he was the case agent of the other case, correct?
Okay. So he may or may not have, he may have relevant information. Again, I guess that's a wait and see. What about, who's Weaver Barkman?
So he's a ballistics expert.
Is that an expert? So that's an expert. Do you have an expert report that's been disclosed?
Not yet, Your Honor. We're working on it.
Your Honor, since I
Her voice just like gets so quiet and like meek and mild when she knows that she's just a horrible attorney for herself. It's like the school teacher asking you if you brought in your report for that day, and you're like, not yet, Mrs. Grunderson. I just, like, I'll get it to you as soon as possible. Like, it's that. I wonder how many people she has been able to manipulate with that. But this is like not the usual side of her that we've seen like through most of the hearings in the first trial.
I've seen a lot of sides to Lori Vallow. None of her behavior shocks me anymore. I've seen woman sit. I've seen her sit like a zombie herself during a whole trial and speak up at the end and say nobody was murdered here. This is why Lori is representing herself, because she knows the attorneys that she does get are not going to believe what she's telling her, and she doesn't feel they're going to fight for her. She wouldn't even cooperate with the Idaho attorneys because they didn't believe what she was telling them.
Right. And she wouldn't let them bring anything in about Chad, right?
Nothing. She has never one time tried to throw Chad Daybell under the bus.
Since I've not noticed a ballistics expert, that's a big problem, because if I get something, then I would have to do that. So the defendant's, again, extremely late violation of all rules of criminal procedure is a problem.
It is a problem.
It is a problem.
Who's Jeffrey White?
My investigator.
Oh, okay. And
Judge, this dude has been in your courtroom before. He sat with her every single day of trial.
This judge sees a lot of cases. Okay, Lori Vallow, he ain't just here to study Lori Vallow. He's got a whole docket of people he's got to look at all day, every day. She's just another one.
I know it. It's just like Jeffrey White. Jeff White's got to be like, wah, wah.
Right? He's like, you're just another defendant, lady.
And you're just another investigator for another defendant. But he
Exactly.
mentions him later. He mentions him later in an interesting way.
do you have an idea of in what capacity you think he would be called?
Well, we had made a request from the state for the car door and the window that the bullet supposedly hit. And and we were going to have him inspect that as well. We have recently found out that those two things do not exist.
Okay, listen to what the judge asks her. He asks her what Jeffrey White's relevance is in this case, why he's on the witness list. And she starts answering for that other dude on the witness list, Weaver Barkman. Like, Weaver Barkman is her ballistics expert, so she does not hear him correctly here. Just so you know, she's not answering that Jeff White is going to be a ballistics expert in this.
My investigator.
Oh, okay.
Okay.
Oh,
Do you
you're
have an
confusing
idea
me.
of in what capacity you think he would be called?
Well, we had made a request from the state for the car door and the window that the bullet supposedly hit, and we were going to have him inspect that as well. We have recently found out that those two things do not exist.
Don't exist.
So
Do you want to hear that again? I want to hear that again
No,
too.
she's saying, she said she's requested the window and the car door, and now she's finding out they don't exist. I'm like, that doesn't make sense, Lori. That's critical evidence. It has to exist.
Well, the window was shot out, so it might be in
Well,
like
I
many,
mean,
many
yeah,
pieces.
the window itself is not, I get that part, but she,
Yeah,
okay.
it doesn't make sense.
the car door and the window that the bullet supposedly hit, and we were going to have him inspect that as well. We have recently found out that those two things do not exist. So
Wow, that's a problem,
Where's the door
right?
with the bullet hole? If you don't have that, what are we doing?
That is a problem. She didn't just say they won't provide it to us. She says they don't exist. Like, did they get
Interesting.
portaled out? It is
I'd like to
interesting.
see I'd like to see the prosecution's reply to that, because I'm curious.
It is interesting. That's like the most interesting part of this hearing so far that I don't
Mhm.
remember like taking note of when I was there. I don't remember her saying that specifically when I was there. It's just so hard to keep up with everything. That's my excuse, and I'm sticking to it.
I'm not sure what they're going to be putting up as far as ballistics in their case in chief. So I was trying to have someone who could be able to look at whatever reports they're trying to put up and rebut anything that they're saying.
Is Mr. White an expert in that area?
Mr. Weaver?
No, I said Jeffrey White.
He's my investigator.
Right, that's who I was asking, who has relevant information. What's Mr. White's relevant information for why might he be called as into trial?
Because he's interviewing the witnesses as well.
So listen to the judge prompting her with legalese right now. Like, she doesn't know how to verbalize her investigator's relevance in the case, and he's going to give her the language right here. He like bends over backwards for her so many times that later on in this hearing is why it gets so crazy off the rails.
The defense witnesses.
So is it some sort of extrinsic impeachment if they,
Correct.
So is it some sort of extrinsic impeachment? Like, she would have come up with that in a million years. Extrinsic impeachment. Come on.
what about Melanie Gibb?
So Melanie Gibb and Zelina Pastinas were both initially noticed in the state's 15.1. They have not noticed them again. I don't know if they can still call them if they're on their list, but they have relevant information to this case.
Have they been presented for an interview by the state?
They've both been interviewed multiple times by the state.
I mean, not by police officers. I mean, by either a prosecutor or someone in her office in preparation for trial.
Deposition lady.
In this case,
Yeah, in either case,
not that I'm aware of.
have they been subpoenaed?
The subpoenas are out.
I signed a big stack of subpoenas, and where they went after that, I don't know. They're out. They're out there somewhere. Maybe they can get Portal 2, but you notice what we're not seeing right here in this video shot is Mr. Jeff White. And he is the one that is responsible for having those subpoenas served. He's not responsible for necessarily personally serving them himself, but he is making sure that like process servers, whether it's the county sheriff's office, the city police department, somebody serves those to these witnesses.
Yes, they do.
And her response is the subpoenas are out. She doesn't say they've been served. That's not the question, lady. If you don't like your potential answer to the judge's direct question, then you must like change up your response. Got to answer what he didn't ask you.
Both been interviewed multiple times by the state.
I mean, not by police officers. I mean, by either a prosecutor or someone in her office in preparation for trial.
In this case,
Yeah, in either case.
not that I'm aware of.
Have they been subpoenaed?
The subpoenas are out.
What relevant information would they have?
They have relevant information to Brandon Boudreaux
Okay.
and around that
What
time.
is the nature of that relevant information?
It will come apparent if they have to get up and testify, Your Honor. I will only call them if I
Okay,
need
well, they're going to
them.
be precluded if you can't give me some minimal what relevant information they have. Just saying that they're relevant doesn't make them relevant.
What? You're going to tell that to a narcissist? Just
Well-
saying that they're relevant doesn't make them relevant? Let's go back and hear that one more time, because this is where it starts to get spicy.
Some minimal what relevant information they have. Just saying that they're relevant doesn't make them relevant. Okay?
Yes, and is this procedure that I have to say what each of my witnesses are relevant ahead of time and give my whole case in chief over to the state? It is?
Yeah.
That's
just
how
like-
it works?
like
That's
the-
the rules of law?
Stop interrupting me. Yes, that is the rule of law. That's just what the state does. They tell you what relevant information each witness has. So my answer is yes. So if you can't tell me what relevant information they have, they'll be precluded.
They both have had dealings with Brandon Boudreaux and Alex Cox. So
Their relevance is that they both had dealings with Brandon Boudreaux and Alex Cox. They both had dealings. That's the relevance that she states right here for
Does
Judge
she think they're
Beresky.
going to come? Does she think they're going to come back up her zombie stories? They have no other relevance. If Melanie and Zulema want to march their tails in court, I'm ready for it. And I'm here for it. Bring them on in, because I got a lot of questions for Zulema as well as I do Melanie. A lot of people are underestimating Zulema.
And I
I'm
think
not.
Trina K might have some questions for him too.
I'm sure she does.
Okay, so does someone, that was a server for them at a restaurant. It doesn't make them have relevant information as to this case. Anyone who came into contact with Mr. Boudreaux or Mr. Cox had some interaction with them at some point in their lifetime does not make them a relevant witness. So what is their relevance?
the state had them on their witness list and they're saying they're not relevant?
Apparently,
Immediately, she's deflecting to the state. But so that's like a twofold. That's like a narcissist that doesn't understand the law. So just because the state has them on their witness list does not give you the right, or does not give you the relevance to put them on your witness list. Let's just say that. So
Well, she can
But
get them
she's
on
already-
cross.
yeah, exactly. Yes.
apparently not. Are you calling them?
No, they're not
Right.
on my,
Police interview however many people they interview because they're working on the case. They don't know who has relevant information, who doesn't have relevant information. All the people that they interview don't end up being relevant. So because they're listed in a police report somewhere, doesn't necessarily make them relevant.
Okay, their relevance lies in if they have to rebut something that the state puts on in their case in chief.
The relevance relies in the fact that I may have to rebut something that the state argues in their case in chief.
Mm-hmm.
That's like,
But she already knows what the witness list is. They do have to turn over certain relevant information about these witnesses. Then it's up to Lori to read through that and decide, what am I going to do to rebut these particular witnesses? So
right,
follow the
but
law, Lori.
exactly. Like, just because the state has a witness on their witness list does not mean that you get to include that same witness on your witness list just for quote unquote rebuttal. I may need to
No,
rebut.
that's what cross-exam is for.
Uh,
Now, if she felt they had relevant information, she could absolutely put them on her witness list. But she's not wanting to talk about what their relevance is because there's probably not any. She's pretending it's because she don't want the state to know her case, but her arguments will be, well, it's not flying, Lori. You still have to say what the relevance is. It's the law.
yes, the
Discovery.
relevance to your case, not just relevance to the
To the
situation.
defense. That's what I said.
Yes.
Yeah, they have to be
Yeah.
relevant to her defense. Is what. Yeah.
Yep.
They're just called in case they need them.
In case I
They're
need
subpoenaed
them.
in case I need them.
All right. It sounds like they don't have relevant information.
Hmm.
However,
Sounds like it.
I'll include these names on the potential witness list for screening the jurors if the jurors have any knowledge of any of these witnesses, out of an abundance of caution. That's really the purposes for today, is the questionnaire that goes out to the jurors. So I will include these witnesses. Again, Mr. Dworkin, Mr. Barkman, if they're expert witnesses that haven't provided any sort of report or expert witness testimony, they're likely to be precluded as witnesses. But I'll include them on the witness list.
She's not going to have anybody.
I think what I'm hearing is you said you might finish on the 9th or the 10th? I'm going to indicate on the questionnaire to the jurors, potential jurors, that the trial is likely to end by June 13th, Friday, June 13th. However, I'll include that Monday, the 23rd, and kind of say, if needed or if required.
So the reason we have to go from the 13th to the 23rd is because that third week of June is blacked out. Like, Judge Beresky is not available for trial. He's got some kind of continuing education or conference or training or something that he's got to go to the third week of June. So if it doesn't wrap up by Friday, June 13th, they are holding back June 23rd as a possible last day of verdict watch. It's going to be done. We're going to have a verdict by June 13th.
Oh yeah.
Might
I don't
go to
expect
June
that trial to
23rd
last
out of an
long.
abundance of caution.
Nope.
So I'll finalize that questionnaire. It's pretty much done, and it's pretty much the same as the last one, except for the names of the witnesses, the specific allegations, and then I removed the question about viewing medical examiner autopsy type photos because that's not needed in this case.
I didn't catch that the first time either. I thought he was saying I'm adding the question about autopsy photos, medical examiner reports. He's like, no, we don't have them because we didn't have them in this case because Brandon's still alive. The coroner and medical examiner were not needed.
For the names of the witnesses, the specific allegations, and then I removed the question about viewing medical examiner autopsy type photos because that's not needed in this case. but I'll send you guys out a copy. Actually, I could probably finish it in the next couple minutes and print out a copy so you have it before you leave here today. That questionnaire, I need to get with the jury office. I think we were talking about sending it out the 22nd and cutting it off the 28th or 27th. And then we'll meet again on the 29th in this courtroom to go over the responses. That'll be at 1 p.m. on the 29th.
Your Honor, in light of the juror misconduct or the alleged juror misconduct, I have to object.
This is my favorite moment for lawyer Lori. This is like, it's my favorite one of the day. And it's one where I almost laughed out loud in court. I may have giggled, snickered, but under my breath.
Object to us having so much information go out about my personal information in that jury questionnaire. Do you not think that was a problem?
What personal information?
The state versus Lori Daybell.
My personal information that the state of Arizona has filed charges against me and is taking me to trial. State versus Lori Daybell is my personal information going out on the juror questionnaires. Like, I got to back up. I got to hear that one more time. I'll try not to laugh and pause this time. We'll keep on going after this. I promise. Good Lord, lady. And Judge Beresky's got to be thinking this just like a little bit.
I have to object to us having so much information go out about my personal information in that jury questionnaire. Do you not think that was a problem?
What personal information?
The state versus Lori Daybell.
What's the name of the case?
Yeah, but you don't put that on anyone else's questionnaire or one other person that's ever had that questionnaire ever put out with their name on it. They just don't do it.
Ever. They just don't do it.
Okay.
No, go ahead.
It depends. Are they mailing out questionnaires? Are they handing them out to the ones they're about to pull? Right? The ones are they mailing them out to get preliminary questions out. And then they'll start the pull from when they get those all mailed back in. She's almost right with this. Like, it depends on what, I haven't seen the jury questionnaires. I don't know what context she's talking about here, but we just went through this whole big fiasco in Idaho for damn jury questionnaires. They're about what they are allowed to know ahead of time and what they're not, or what, different questions. It was a whole big hearing had to be held on that stuff. So right. I kind of see
the defense did a survey, right? Yeah.
Yeah.
Listen to Judge Beresky's response to this, though.
Yeah.
And
I'm curious.
It settles it in my mind. So I'm going to let it play all the way through that so you can hear all the way.
Okay.
Your Honor, in light of the juror misconduct or the alleged juror misconduct, I have to object to us having so much information go out about my personal information in that jury questionnaire. Do you not think that was a problem?
What personal information?
The state versus Lori Daybell.
What's the name of the case?
Yeah, but you don't put that on anyone else's questionnaire or one other person that's ever had that questionnaire ever put out with their name on it. They just don't do it.
Do it in every trial I've done.
And then the people are just going to Google it, and then we're going to have the same exact problem we had getting a jury for that case. We're going to have the same exact problem.
Are you done? Are you just going to keep? Okay. How do we screen for if people have heard about you if we don't include your name?
Thinking.
Do you have a response to that?
I'm just saying, you gave them the name and they're just going to Google it.
They're instructed not to Google it. All right. And if you'll recall, when we had all the jurors come in person, one of the first questions I asked them in the afternoon was, who has looked up this case since you filled out the questionnaire? And we had 2 or 3 people raise their hand, and those people were excused.
Word.
So I have to include your name to screen out for the people that know about your case. And we released about 100 jurors last time because of their answers to that. If we don't include your name, that's 100 extra jurors we have to go through in person and ask if they know you. And in fact, that increases the risk of tainting the rest of the jury pool if we have someone stand up and say, yeah, I know about her case in Idaho where blah, 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 in front of the rest of the jurors. That'll burn the whole panel. We'll have to start over.
That's a really good point. Like,
Yeah, it's the jurors that when they come down to trial, those jurors aren't supposed to know, right? Like in her last trial, they weren't supposed to know about her past. But when you're trying to get to the jurors, like he just explained, putting your name helps us weed out the ones that do know who you are. But then she's thinking, well, what if those that didn't know me then, yeah, how do you know they're going to be honest about Googling me? It's a double-edged sword, if you ask me.
it is, but I like his point better because he
I get
says
it.
so.
Mm-hmm.
Yeah. So they stand up. So somebody that does know about it, that wasn't asked about it,
Right.
then is asked about it in front of a bunch of other jurors, they could taint the rest of the jury pool by saying, yes, I knew about, yeah. I like the way he handled that. And he kind of had like that secondary thought, like, oh yeah, this is like doubly bad if we don't ask them. So I'll replay just a little bit of that and then we can move on. But somebody made the point that she has basically already agreed to the format of the juror questionnaire. I don't know that I've seen that.
It would be in the docket.
Yes. So supposedly somewhere towards the end of the last trial, they held a hearing about the juror questionnaires in this trial. So I may have been so caught up in the other trial, I missed that. But we can go back and find it. But if she did, in fact, agree to it, then her objection is a little bit late, like pretty much everything else she does.
That know about your case. And we released about 100 jurors last time because of their answers to that. If we don't include your name, that's 100 extra jurors we have to go through in person and ask if they know you. And in fact, that increases the risk of tainting the rest of the jury pool if we have someone stand up and say, yeah, I know about her case in Idaho where blah, 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 in front of the rest of the jurors. That'll burn the whole panel. We'll have to start over. So I'm going to include your name in the questionnaire. I don't think there was any other personal information or background information about you in that questionnaire other than your name. So was there any other issues you had with the questionnaire?
No, Your Honor.
Did you see the way she flipped those glasses down? She's getting so frustrated.
I've got no comment. I'm part defense attorney and part prosecutor. I don't really have a comment.
Right?
I'm just going to remain silent because it's Lori Vallow, or excuse me,
And
Lori
she's-
Daybell.
And she's part defendant and part defense lawyer.
Yeah, I digress.
Blah, 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 in front of the rest of the jurors. That'll burn the whole panel. We'll have to start over. So I'm going to include your name in the questionnaire. I don't think there was any other personal information or background information about you in that questionnaire other than your name. So was there any other issues you had with the questionnaire?
No, Your Honor.
So the schedule will be, we'll meet 1 p.m. to go over those answers on the 29th. On the 30th, we'll meet at 10. We'll have walk-in jurors that morning that will fill out the questionnaire. And then the people that survive our screening on the 29th, and those that survive the morning of the 30th will come in the afternoon of the 30th. This will be back in the courtroom we were in last time, 5D of the South Court Tower.
Yeah, that's a good thing. This courtroom right here is tiny. It's 1/3 the size of 5D. And it almost filled up today, and there was not like anywhere near the presence that there was during the trial. So it's good he's moving it back for jury selection, but also partly because they use the seats in the gallery for part of the jury. So if they use those seats in this courtroom for the jury during jury selection, there would be no room for the media and the public, which that's up to the court to do. If the court wants to exclude the media and the public, they can. but they chose to move jury selection over there. Reviewing the juror questionnaires on May 29th will be in the same courtroom. That's a very much smaller event. There shouldn't be like any media presence at that. And it may be actually excluded from the public reviewing the jury questionnaires. So with the last trial, with the 2021 Charles Vallow case, they sent out 200 questionnaires. They went through their first day of weeding out people who had heard of the case or who had hardships. They ended up with 55 people that they brought in on the next day for group voir dire and individual voir dire. And that first batch of people that they released after group voir dire, there were like, I think they released 14 from that first one. So there were like 40, and then they seated 18 people in the jury box, and they took 16 of those 18 people in the jury box for the final jury. So it went fast. Like they released, I don't know, 30 people who hadn't even been individually voir dired from the jury. So that's what he's expecting to go down with this next time. I will be impressed. Go ahead.
There's just a standard jury stuff, you know. I mean, it's part of it.
But you also, right? But you also, there are juries that take a week or 2 weeks to get seated, and he did it in 3 hours. He did it in 3 hours, and I'm like,
I know,
damn, Judge. And
I
he's
know that
expecting to
made
do
me
the
a little
same thing
nervous.
again.
I've seen too many times it take longer than 3 hours. I'll be honest, it made me a little nervous when that happened, and look what happened.
Yep.
Juror 15 happened.
Yep.
Again, I expect to seat that jury at some point that afternoon.
He just said it again. I expect to seat them that afternoon. But if by any chance, like this case has brought more attention, okay, so here's a little story. So I said I got there at 8 o'clock in the morning, right? And I'm the first one there. And then people start sitting in the seats around me. And there's some defendants and there's some attorneys for the cases that are being heard by Judge Beresky before Lori's case. The very first guy that sits down next to me, I'm like, hey, did you know that Lori Vallow Daybell's hearing is going to be after yours? And he's like, who? Like, seriously, you haven't ever heard of her? He's like, no, never heard of her. So
Is that shocking?
Do what?
Is that shocking?
No, it's not. No, my experience has been, I stop at grocery stores.
Yeah.
I stop at Walmart. I stop all over the place out here, and lots of people in Maricopa County have not heard of Lori Vallow Daybell. Lots of people.
I try to explain that about Idaho as well. People don't want to hear it. I've got friends that live in that area. I've asked. People not everybody knows about these cases. Like I've said, I don't watch my local news. My kid has to tell me when something's happened because I'm always on the YouTube, right? So a lot of people don't, they don't know. They don't pay attention to that stuff, especially if they're criminals themselves. They're not like studying the news unless they're looking for themselves.
Right. So I happened to go to the bathroom and come back. And in the meantime, his attorney showed up and they were having a little attorney-client conference. And when I was coming back from the bathroom, he pointed at me and he goes and said something to his attorney while he was pointing at me. And I'm like, and I get up close and he's like, his attorney said, oh yeah, I kind of know about that case and we want to get out of here as soon as possible. And I'm like, if there's an attorney that's having a felony trial coming up in Maricopa County and he doesn't know about Lori Vallow Daybell, that says even more to me than like his client doesn't know about her. Right? He's like, I kind of know about her and we want to get out of here. He knows more about her press coverage than he knows about her case. Yeah.
Well, yeah, he's got his own caseload. He's not her, involved in that case. So.
Right.
And then we'll plan on going Monday through Thursday, June 2nd to June 5th. Then June 9th to June 13th, and if need be, June 23rd.
They don't have to vet all
Your Honor?
witnesses
Yes.
at Daubert's.
I have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
And what
Wait, what? What, Lori? What did you just
What?
say?
I'm on mute out so I can not laugh. I got to hear that again. It's the
And
first time she
listen
got me to laugh.
listen to her say, Your Honor, like it's not her usual little girl voice that she uses when she wants to like get her way. This is like, Dad, like I don't think that my allowance is enough, and I think you need to like give me more allowance or whatever. Like it's not her little girl voice, it's her whiny
If she's
voice.
about to, Your Honor, I'm going to tell you something you ain't going to like.
Okay, and here's the other point I made earlier. She's getting ready to say something that she has rehearsed. She has rehearsed this little speech about asking him to recuse himself, and she has a little script like in her mind. So she starts down her script. So the Your Honor is like the beginning of a soliloquy. Like she's going to give her little speech, and then she expects the judge to have a certain response back to that. And when he doesn't, it may go off the rails.
No, Your Honor.
So the schedule will be, we'll meet 1 p.m. to go over those answers on the 29th. On the 30th, we'll meet at 10. We'll have walk-in jurors that morning that will fill out the questionnaire. And then the people that survive are screening on the 29th, and those that survive the morning of the 30th will come in the afternoon of the 30th. This will be back in the courtroom we were in last time, 5D of the South Court Tower. Again, I expect to seat that jury that some point that afternoon. And then we'll plan on going Monday through Thursday, June 2nd to June 5th. Then June 9th to June 13th, and if need be, June 23rd.
Your Honor,
Yes.
I have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
And what personal bias is that?
A lot, obviously the personal bias that you're showing right now and that you've shown on the FTR several times during the trial.
Okay, well, I don't have any personal bias, all right? I've over accommodated you on when you have to disclose things. In fact, your expert should be summarily precluded today, and I haven't done that. All right? So
You denied every single one of my motions since for a year and a half that I've been here. Every single one of my motions has been denied. And have any of those motions not have merit? You've denied every single motion.
I think I was here this morning about 15 minutes ago when I granted your motion to meet with your attorneys over the lunch hour.
All right, I got to stop it there. That's not a Nancy Joe moment, but that's that's a mic drop moment. I think I was sitting here 15 minutes ago when I just granted your motion to meet with your team during lunch hour. I think I may have been sitting here. So I'm going to rewind. I'm going to play that again. Pay attention to her head bobbing like left to right. She's like shaking her head, and she's like, so, and we can't see the front of her face because the camera is directly behind her, like literally, but you know, she's got her face like tilted up a little bit, and she's like, got that defiant, like that
She's
defiant
frustrated.
thing going on.
Mm-hmm.
Yeah. One more time.
A lot, obviously the personal bias that you're
A
showing.
little more.
People
little
that
more.
survive are screening on the 29th, and those that survive the morning of the 30th will come in the afternoon of the 30th. This will be back in the courtroom we were in last time, 5D of the South Court Tower. Again, I expect to seat that jury that some point that afternoon. And then we'll plan on going Monday through Thursday, June 2nd to June 5th. Then June 9th to June 13th, and if need be, June 23rd.
Your Honor,
Yes.
I'd have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
And what personal bias is that?
A lot, obviously, the personal bias that you're showing right now and that you've shown on the FTR several times during the trial.
Okay, well, I don't have any personal bias. All right. I've over accommodated you on when you have to disclose things. In fact, your expert should be summarily precluded today, and I haven't done that. All right. So
You denied every single one of my motions since for a year and a half that I've been here. Every single one of my motions has been denied. And have any of those motions not have merit? You've denied every single motion.
I think I was here this morning about 15 minutes ago when I granted your motion to meet with your attorneys over lunch hour. I have granted other motions of yours. Okay.
That's the first motion that you've ever granted
Well,
in my behalf.
file motions that have,
Is she not a narcissist, like a typical narcissist? Like, you have never granted any of my motions. And he's like, girl, I was just here 15 minutes ago and I granted one. And she's like, well, that's the first one. That's the first one ever. And he's like, no, I've granted other motions and I'm about to go down the list of other motions that I've granted for you. And it may not be a complete list, but I have granted other motions. Her level of narcissism, like the back of her hair shaking for some reason is like bugging me right now. She's super agitated. She is super agitated.
Thursday, June 2nd to June 5th, then June 9th to June 13th, and if need be, June 23rd.
Your Honor,
Yes.
I'd have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
And what personal bias is that?
A lot, obviously, the personal bias that you're showing right now and that you've shown on the FTR several times during the trial.
Okay, well, I don't have any personal bias. All right. I've over accommodated you on when you have to disclose things. In fact, your expert should be summarily precluded today, and I haven't done that. All right. So
You denied every single.
Okay. She completely ignored that, but I picked up on that in court. So if you remember, all of these camera shots of her at her defense desk have her defense attorney, her investigator off to the right. And the point I made earlier is when he was in an earlier pretrial hearing for the 2021 case against Charles Vallow for her murder of Charles Vallow, conspiracy to commit whatever, he was allowed to come in and sit, but only after they asked for permission. Today, he just came and he sat down at the defense table. Like they did not ask for permission. He just came and did. And Judge Beresky just says, I allowed for him to come in and sit down, even though he could have been, should have been precluded from, in joining the court. He's an investigator. He's not a law person. Like, he has nothing to do with her legal defense team. He's an investigator. So he has to help her with her legal defense in certain ways, but not inside the courtroom, even though he was there every single day for trial. So that's interesting.
Okay, well, I don't have any personal bias. All right. I've over accommodated you on when you have to disclose things. In fact, your expert should be summarily precluded today, and I haven't done that. All right. So
You denied every single one of my motions since for a year and a half that I've been here. Every single one of my motions has been denied. And have any of those motions not have merit? You've denied every single motion.
I think I was here this morning about 15 minutes ago when I granted your motion to meet with your attorneys over the lunch hour. I have granted other motions of yours. Okay.
That's the first motion that you've ever granted
Well,
in my behalf.
file motions that have a legal basis, and I might grant them.
So you're saying none of my motions have had merit?
Not many, no.
And none of the motions that my first team You denied every one of my first team's motions. You denied every one of my second team's motions. And now you denied every one of my motions until today.
I haven't denied every one of your motions.
Every single one.
So in this situation, the look on his face, like I wouldn't know how to deal with her, because when you're dealing with a narcissist, you have to make a choice. And he made it earlier to just let her have her say and then be like, are you done? Are you done? But then when you get into like a detailed argument, she like sucks you into that detailed argument. Like, I have granted some of your motions. So, but when you're in a courtroom, it like makes that decision like exponentially more impactful. Because if you just ignore all of her arguments, then that can be some type of grounds for appeal, maybe down the road. So you can't just ignore them all and just say, are you done? Are you done? Are you done with whatever you're going through right now? You have to like address some of them. And I think he's doing a pretty good job here. But that look on his face like says it all. Judge B, go. I hope you got in your convertible at the end of the day today and like put the top down, put your shades on, and just put some kind of jam on the radio and cruised home in your awesome convertible, because he has one. Hey, welcome in, chat. Welcome in, everybody. Chat, Trial TV Live. Thanks all for coming and crashing. You're coming in at the end of this. Like, we're 2 hours and 11 minutes in. I went through the court documents first, and then because the court documents of the motions that they talked about at the beginning of this, and then we've gone through, and Salty and I have like stopped to comment on this. This is her first take. She hasn't seen the video yet, so she's had some good first takes on this. But we're getting close to the end of this, and it's been a crazy day. If you're going to go with that analogy, then let's go back to the first trial and the fact that Trina K was leading on almost every single question with every single witness. Like, if Lori had been a good lawyer or had a good lawyer, she would have been objection leading like 15, 20 times a day. And eventually they would have reached an agreement where Trina was not like leading all the time. She would have been a little more careful with it, but she wasn't, because Lori didn't ever object to any leading questions ever. She did not ever offer an objection leading.
If Lori had an actual attorney, these hearings would be very different, and so would the trial.
Yep. Agreed. But I like that analogy, because I made the analogy. That's like the varsity basketball team playing the freshman basketball team, and they're dunking on them like every time down the court. Trina's dunking on Lori every time down the court. And the referees aren't going to stop it, because there's nothing illegal if they don't call something. But what if the varsity person who's dunking takes 3 steps and it doesn't get called? I'm going to take 3 steps down the court every time before I dunk. If it doesn't get called, it's not a foul. If I don't get caught speeding, I wasn't speeding. Oh, that's a good analogy, though. I like that. All right.
Single one of their motions was denied. Every single one of the second team's motions were denied, and all mine. So you didn't come into this with any bias against me in the first place?
Again, file a motion that has legal merit. Okay.
And none of my attorneys ever filed a motion.
That was a little bit of snark from Judge Beresky, and I missed that. I missed that in court today. Well, file a motion with a little bit of legal merit. Okay. I got to replay that. That was classic.
Motions were denied, and all mine. So you didn't come into this with any bias against me in the first place?
Again, file a motion that has legal merit. Okay.
And none of my attorneys ever filed a motion with any legal merit?
They filed a motion on your behalf, the first team, to preclude media coverage, and I issued my ruling according to the law. All right. They filed a motion to have you dressed out not in jail clothes during hearings like this. Okay, that was not based in law. I denied that motion. So I've ruled on the motions as required by law.
Without any kind of a conclusion of law in them, just denied, 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 denied. Does that not show a bias and a prejudice against one single person?
All right, are you done?
Are you not going to recuse yourself?
His blinking in this is classic to me. Like his blinking. I'm trying to find an analogy. Like,
I am never putting my face on the YouTube streets. It's never gonna happen. My face
When-
will tell you all kinds of messed up stuff.
your
Not
face
even
will tell a
joking.
story.
Oh, it does.
I'm just-
It tells a big story.
I'm just looking at his blinking, and when he says something that's like, "Are you kidding me?" is what I relate to the blink. That's what I'm looking at the blink rate. Like,
Oh
are you
yeah,
kidding
it's
me? Are you kidding me?
general.
Are you kidding me? Are you kidding me?
Denied, denied, denied. Does that not show a bias and a prejudice against one single person?
All right, are you done?
Are you not going to recuse yourself?
No, I'm denying your motion.
Blink.
Anything else? All right, I was handed a motion to suppress all evidence pertaining to Jeep Wrangler.
I have not received that.
Did you probably got a copy of it today or not?
No.
Oh, do we need to make copies?
Did you hear that, Salty?
I did. So they claim that Tylee's Jeep was used, right?
Yes.
When they shot at Brandon. So that's interesting
Yeah.
that she wants the whole Jeep left out.
Yep.
Was it processed? What they find in the Jeep, Lori? We find gun residue, gunpowder, or anything like that, Lori?
That's what that Tammy Lachik was up there checking out.
Mm-hmm. Oh, I checked
She
her
went
out. I do my homework.
And Tammy Lachik went up to Rexburg to do her homework and get samples
Mm-hmm.
of stuff off of that Jeep. And now Lori wants it out. Interesting.
Where?
I have not received that.
Did you probably got a copy of it today or not?
No.
Oh, do we need to make copies? All right, go ahead and make copies for the state. I also have a motion to dismiss for non-preservation of crucial evidence. So make a copy. I guess the state can file their response to those. All right, anything else for today from the state's perspective,
No, Your Honor.
from the defense?
No, Your Honor.
All right, we'll see everyone on the 29th at 1 p.m. Again, that's in this courtroom.
What is that little smile that she's giving to her advisory council? Like, she's done it multiple times on this, and I've been asked about this, like who was sitting over there. That's Abernathy and Hicks are over there to her left. Like, I don't understand that little smile.
What do we need to?
Well,
Could it be like a
after
acknowledgement,
after
or
this-
is it like has she discussed something prior about these motions, or what she was going to say to the judge? Is I don't know what she's looking at them for. You know what I mean?
I
It could
guess
be a lot
go
of
ahead.
reasons. No, I'm just thinking it could
I
be a
guess
lot of
I'm-
reasons why she's doing it. I don't know.
I guess I'm so tainted by her trying to
Mhm.
manipulate people that I look at it as manipulation. And
Yeah,
she did have a little tete-a-tete with Pam Hicks after this hearing over in the corner where she was sitting. But I don't understand the smile. Like, why do you
Perspective
watch this
No, Your
smile?
Honor.
from the defense.
No, Your Honor.
I'm
All right,
probably
we'll see
I
looking.
guess
everyone
she's trying to
on the
manipulate her team.
29th at 1 p.m. Again, that's in this courtroom.
All right. Do you want to watch any other part? Do you want to watch any part of that again? Do you have an
I don't.
interest?
No, I've seen all I need to. I took all of it in.
I just got 2 new documents on the court docket that came down. So what if we take a look at those?
Mm-hmm.
I've got to pull them up out of my downloads file. These are hot off the press. They were not in there this morning. They were not in there this afternoon when I got home. Pro-per notice email in response to defendant's motion. Oh, so one from Lori and one from the state. So Lori's is typed up nice and neat. This is Rule 15 notice of defenses and disclosure. These are her witnesses. Oh boy, do we want to look at that? Or do we want to look at the state's response to defendant's motion for time to consult with advisory council and team?
It's up to you.
Let's do the boring one first.
Which one do you think's the boring one?
Oh, the state's response to her request to meet with her team.
Oh.
All right, present, share screen. This is hot off the press, people. Like I literally just downloaded this from Maricopa County Superior Court. All right, so this is, we heard today that she filed a motion, and we saw that motion that she wasn't allowed to meet with her team, advisory council and team during trial in the last trial, and she needs to in this trial. This is the state's response to that. We already heard today that the judge said, okay, we'll figure something out. Not a big deal.
Yeah.
Still interesting to watch, to see the state's response. Non-party Maricopa County Sheriff Jerry Sheridan. I wonder if he's the guy that was in court today. I think he probably was, sitting to the right of Trina Kay. Hereby files his response to the defendant's motion. Maricopa County Sheriff's Office takes no position on defendant's request for additional time. However, should the court grant defendant's request, the Sheriff's Office does not object to arrangements for such time and provides the court with the details on such arrangements. Oh, details. We're going to see details. I like details. Maricopa County Sheriff's Office has determined that if the court permits, defendant can choose to remain in the courtroom with her legal team during court recesses. This will negate the requirement to return to her holding cell to wait for her trial to resume. Additionally, as it pertains to the lunch breaks and other recesses, and should the court permit, Maricopa County Sheriff's Office will transport defendant to level 4 in the South Court Tower. Oh, now we know where she's going. Now we know where she's going, level 4, which houses a built-in visitation area that contains secured legal visitation rooms. Maricopa County Sheriff's Office will provide defendant with a sack lunch. What do you reckon's in that sack lunch? What do you think is in that sack lunch that the Sheriff's Office is providing to Lori?
Peanut butter and Karo syrup mixed together.
Oh, gosh.
That's what you get at our county jail for lunch, I was told. Instead of peanut butter and jelly, they mix it with Karos. My aunt used to work at the county jail in the kitchen. She was like the head cook lady, and she would tell me stuff. And that's when one time we had a new sheriff. Years ago, we got a new sheriff, and he's like, "I'm done with you guys having lunch. You're getting peanut butter and jelly and nasty little ham sandwiches." It wasn't peanut butter and jelly; it was peanut butter and Karo. Come to find out.
Oh, gosh.
It was gross,
God.
I guess. I mean, I didn't eat it, but my aunt was telling me about it.
Sack lunch. Okay, I gotta find my sack lunch break and remain in that legal visitation room with her team for the entirety of the lunch break, which means her legal team also has to spend the entirety of the lunch break in that same room. I wonder if they're going to get a sack lunch from the sheriff's office. I don't
No,
think
they
so.
can probably order lunch in. I mean, I'm not really worried about them.
Exhibits. Exhibit 1, rack belt removal. Ooh, this is new stuff I haven't seen yet. This is brand new stuff, people. Like literally, I just downloaded it off the Maricopa Superior Court website. After reviewing defendant Lori Daybell's motion dated May 6, 2025, regarding the removal of her rack belt during her trial, I have the following response. Sheriff's Office requests the rack belt remain in play. That's a cop word. How about remain in place during the trial? Sheriff's Office disagrees that the rack belt can be seen under the clothing. The device has been used over 2 decades by the Sheriff's Office when inmates take part in trials. Okay, well, lots of other things that are not appropriate have been used by law enforcement for over 2 decades. So that's not a valid argument to me. Sorry, guys.
Yeah. It's Lori Daybell. I digress on anything legal. I'm not going to do it.
Right. Just because I take issue with like something that the prosecutor's office says or the sheriff's office says doesn't mean that I'm making any kind of indication of my opinion on the guilt or not guilt of Lori Vallow Daybell, because I'm pretty sure I've made that pretty clear.
Yeah.
So you want to take up with it? Okay, we can have a chat. Daybell is correct that the rack belts are universal and designed to fit a wide range of defendants. So that defendant I told you about earlier that pled guilty in that STX trafficking case before her case was much, much larger than her. And if that rack belt fits him, it's going to be a problem trying to fit that on her too. Like that's a problem.
I've already thought about that, but nobody wants to explore that, because it's Lori. So stick her in whatever y'all want. Just whatever.
Well, I think part of the problem is, so let's go with her presumption that the rack belt is a problem. And we looked over her motion, like at the very beginning of this. So if you want to go back and look at that document, you can. She filed a handwritten motion saying the rack belt like has to be wrapped around her at least twice to fit her, because it's also designed for larger male inmates of whom I was just talking. So it could be a problem. And maybe somebody, hey, here's a business idea. Somebody go out and invent a different size rack belt and sell it to law enforcement agencies everywhere. Sell it to sheriff's offices,
Well, let's be honest. They should have one for the women detainees and one for the men. It can't be that difficult. They're already making them. Just order some that are smaller for women.
Yeah.
Problem solved. It's a no-brainer to me.
So, they are universal. There should be more than universal rack belts. All right, I got to check chat because that was kind of a hot take. Is it effective if it's wrapped multiple times? Holy cow, that is a relevant question. And I had the silly comment earlier. If it's wrapped twice, can it short out on itself and like accidentally shock her? That's a very good question. Or would it be like, if it's double wrapped, would it be like double the voltage or amperage to incapacitate the inmate? Like, have they done testing to see the effectiveness of double wrapped rack belts? I think that may be my next investigative story. Double wrapped rack belts. Don't say that 5 times fast. Daybell claims that there have been many issues with detention officers trying to fit the belt on her. I personally observed the belt being put on her once during her last trial. Well, one time, dude, out of 10 days, 11 days, 12 days doesn't count as definitive observation. It's selective observation. Watched as the female detention officer secured the belt to her waist in under 2 minutes. I'm not sure that satisfies the question for me. If it's an effective method of detention, it was my observation that the detention officer had no difficulty installing the belt. Okay, installing the belt, keeping the belt on, using the belt for effective purposes. Those are other questions I have after reading this. The sheriff's office has staffing concerns with having an armed deputy posted in the courtroom during trial, as that would be one less deputy available to respond to remands, warrants, and other calls. You can't put warrants off for 2 weeks, like those small claims court warrants. You can't put those off for 2 weeks. And other calls for service throughout the court complexes. Sheriff's Office Court Security Division is currently understaffed and operates at less than 50% staffing capacity. So that's noteworthy to me. That may also be an interview that I need to have with somebody. While the sheriff's office staffing is not the defendant's problem, it is nonetheless an issue of concern for the sheriff's office and overall security within the court complexes. Dude, if you take that rack belt off of her and she is unshackled, she's not going anywhere.
Nah.
She's not going anywhere. But I get it. It's a matter for the sheriff's office to offer their opinion and for the judge to offer his ruling, and he did today, and he said the rack belt remains per this request.
I mean,
Now
they
we
have to have some security around her, and they know it. So,
yeah. Okay, but so during the trial, there were two security officers in the courtroom, one on the left, and he's the guy that lets her in and lets her out, and there's the one on the right that was just there for backup. And I was hoping that would be the guy with like the remote control to her rack belt, but I never saw such a thing in his hands. So, but if she's not shackled and she doesn't have a rack belt, she's not going anywhere. Like, even if she gets out of the courtroom, she's going to be tackled within like 30 seconds. I mean, so rack. All right. I'm done with that. That's my thought.
let it go.
Yeah.
Let it go.
Yep. I got to let it go. And just once again say that doesn't mean I think she's innocent, and that doesn't mean I don't think she couldn't deserve a good shock with the rack belt.
Right.
But I try to look at these type of matters, these legal matters, objectively.
Yeah. It's getting harder and harder in true crime.
It is, and I've made a couple mistakes, and I've made a couple of comments and said a couple of opinions that were not objective, that were subjective, and got called out on them. And I've learned a lot. I'm still learning a lot.
It's not hard to be fair when you look at the stuff. It's just, I don't know if people receive it as that way sometimes. You know, these cases take on the life of their own and divide and all that. I'm looking at all different cases. You know, I try to look at it all fairly too, from both sides. That's like I can be your defense attorney or your prosecutor, which one you need. Like, I don't roll with either, you know what I mean? Because, like, can't be all team defense in one case and then hate defense in the other. You know what I mean? You can not care for them or their tactics and things of that nature. But discussing law and discussing the criminal is different. You know what I mean? I mean, I know you know.
If you know, you know.
Yeah, I mean, we all get invested, but when you're trying to look at the filings and the motions and look at them from a legal standpoint, it's like you said, it's not that we're defending Lori in any capacity. We're looking at the law at that point.
Right. And the fact that if she gets a fair trial,
right,
we have a greater chance of seeing justice for Brandon, justice for Charles, justice for
Mhm.
JJ and Tylee. And if she doesn't, then the odds of her, if she doesn't get a fair trial, then the odds of justice go down by some percentage. Is that 2%? Is
Yeah.
that 20%?
Yep.
Yeah. We need to see a good police investigation, and we need to see a fair trial. And
I
then
agree.
we need to see the justice system play out. I still believe in the justice system. I really do. I've seen a couple of verdicts that I didn't think that I would necessarily vote that way if I were on the
Mhm.
jury, but that doesn't mean that I don't still believe in the justice system.
Exactly.
All right. So in defendant Daybell's second motion, she requests additional time to meet with her legal team. I have met with Court Operations Command, and we have agreed that Daybell can choose to remain in the courtroom with her legal team proceeding breaks rather than return to wait in her holding cell for lunch breaks and other times of recess. During court proceeding breaks. Okay, so we're talking about two different types of breaks. So I was having trouble understanding what the difference was here. There's court proceeding breaks. So if the judge says, okay, we need to have a sidebar, or we need to release the jury for something that has to do with court proceedings, then she can remain in the courtroom with her legal team for lunch breaks and other times of recess. They agree to
Like a
transport
10-minute
her.
break and all that. Like, when they go for their 10-minute morning breaks or their 15-minute breaks, all those types of
Yeah.
things.
They're usually, so in the first trial, we never got started until 10 or 10:30. Like no day started before 10 o'clock, and that was only 2 days out of 11 that started at
Yeah.
10 o'clock. Everything else was 10:30. There was no morning break. So there was an hour to an hour and a half, depending on when we broke, lunch break, and then an afternoon break, 15 minutes. So that's what we're talking about. Hour to an hour and a half lunch break and a 15-minute mid-afternoon break. They agree to transport her to level 4 of the South Court Tower. So here's the thing about transporting her to level 4 of the South Court Tower. They transported the jury through the public elevators. They did not have separate elevators for the jury. So there were times when we would want to go to lunch and we'd go hit the down button on the elevator, and all of a sudden the jury liaison would come out with the jury, with all 16 members of the jury, or 14 after day 2, and say, okay, we need the elevators. And it would literally take like 10 minutes to get an elevator and get down to the bottom floor for lunch. So surely the judge has a separate elevator, and that the sheriff's office can use a separate elevator for her to go down and meet with our counsel, and they can use a separate elevator. I would have to
They
assume so.
usually, yeah, they don't usually parade the people on trial out in the middle of where the public's at. Our courthouse is set up different like that. It doesn't happen like that. They have a different, because they're brought in from the jail. They have an area they go into. You can't see it once they're in there. It's like, a Sally Port or you drive into or whatever. And yeah, they have a whole entrance. We never see them until they're marched into that courtroom.
Yeah, and I think we saw in this case that they maybe want to consider the same thing with the jury. Just saying.
Well, the jury, the person escorting the jury around should come out and say, all you grown-ups out here, stop talking for a minute, especially when you see these jurors. I mean, they can only do so much in these old courtrooms, right? So they got to get better at just maneuvering the people around, even if it comes to clearing all y'all out while they get them in and out. Because I know you said in the first trial, y'all could all be out there talking when the jurors were coming out. And I'm like, y'all didn't see them and just stop talking? And you said that,
Okay.
yeah, you had told me that you said to people, hey, there's juror, you know what I mean? So we had that
Yep.
conversation. So it's like, I'm wondering, if that's a problem, that's a logistic issue for the court to deal with. And
It
they better
is,
get,
and they
yeah.
should, because if they can bring the defense, the defendant, and the defense counsel, and the state in, and the judge in through a back elevator that's not a public elevator, they can do that with the jury too. Like, are
I
they
agree.
not offering that to the jury? Like,
Ask them when you're in court. Ask the judge. Stand up and raise your hand. Say, Judge, excuse me, I have a question. All my people want to know.
that's
He
gonna
might
go
answer
well.
you, Joe. He might.
He actually
He may
talked to
not.
me today. He
Did he?
actually noticed. He did. So yeah. So I'm sitting there observing the first hour and a half of his first 8 or 9 cases on his docket, and there's a gal to my left that's just sitting there watching, and there's me on the far right back corner watching. And he looks at me and he says, "Sir, are you observing today for another court?" And I was like, no, that's not me. And then he looks to her and he's like, "Are you observing for the other court?" She goes, "Yes." So, I mean, he talked to me. So he's approachable. He's a cool guy, but I don't think I'm going to stand up and ask him that. But I do have contacts with the court, and I honestly think that they could do a better job the next trial, like segregating the jury from the public and media.
Do I got a suggestion box down there?
They do not. They're like suggestions not welcome. Especially judges. Judges are not welcome to suggestion. They're like,
Doesn't hurt to try.
they're like, I know what's up. I know what the law is. And
It's my courtroom, my courthouse. You just mind your business.
exactly. Exactly.
Let me worry
All
about
right.
these jurors.
So here we go into the 15.2 Rule 15.2 Notice of Defenses and Disclosure. Much shorter list than the previous one. It says 513. So it was uploaded yesterday, but it was not on the court downloads until today, just a couple of hours ago at the most. Defendant's supplemental Rule 15 Notice of Defenses and Disclosure. The defendant submits the following supplemental disclosure pursuant to Arizona Rules of Criminal Procedure 15.2. Expert witnesses. The defense notices the following witnesses. The defendant. Oh, really? You're noticing yourself, Lori? Lori is noticing herself. Like that has a double entendre. Lori is noticing herself as a potential defense witness. Any and all individuals, including but not limited to victim, assistants, caseworkers, and or volunteers who have spoken with any witnesses in this case. Dude, she's filing this. Let's see. Opening arguments are June 2nd. She's filing this 3 weeks before opening arguments. All witnesses listed in the state's Rule 15.1 disclosure. If you listed them, I'm listing them too. You don't get to list them without me. Oh my gosh. As well as in any supplemental witness disclosure filings, the custodian of records for any and all exhibits. She did this in the last one, and it went nowhere.
Well, she got this all out of her law books, but the thing is, she doesn't have a team to help her handle the amount of stuff she's wanting turned over. So once if she actually was to get it, what she's going to do with it, I don't know. She doesn't have a full-on staff.
Yeah, and if she had a team, like if she didn't file to represent herself, maybe they could have done something with some of this in a timely fashion. This isn't going anywhere. Lonnie Dworkin, didn't she say in the hearing today, I'll get you his report as soon as possible?
As soon as possible.
And Weaver Barkman, kind of the same thing. And Detective Moffat, we don't have anything thing from Detective Moffat, Jeffrey White. And she said, well, he interviewed some witnesses and he said, well, that's extrinsic impeachment. She's like, yeah, that's the ticket. Extrinsic impeachment. That's what I meant for Jeffrey White. Then we have Melanie Gibb and Zulema Pastanes. What odds would you put on her getting any one of these defenses or witnesses in after the state wraps up their case?
I mean, she might be able to. They're on her list. The judge wanted to know why the other two needed to even be on there, Melanie and Zulema, if she can't, because you got to depose these witnesses, right? That's a legal thing that happens in all cases. They got to be deposed. And yeah, does she have time for all that? I doubt it. It's just Lori reading some law books and going, oh, I need to do that. But then she doesn't know what to do beyond that.
Yeah. Like I've said multiple times, she doesn't know how to land the plane.
Yeah.
She'll come in and make an approach, but she doesn't even do a touch and go. She gets down to 1,000 feet and she's like, I'm not comfortable with this. I don't know what I'm doing. I might crash and burn.
Yeah, and I don't know how
back.
hard her investigator is really working for her. How good he is at his own job outside of Lori's case. I don't know what all's going on there, but it's obvious she's not a lawyer and she doesn't have a full staff to help her, so it's hurting her.
I am not impressed with her investigator because
me either.
Judge asked her, have Melanie and Zulema been subpoenaed? And he is the one that is responsible for those subpoenas.
Yeah.
He doesn't have to personally deliver them. They can be through a process server, but he's sitting right there next to her looking at the judge and he says nothing. He totally, completely ignores the question and response and does not do anything. And I'm like, dude, can you be like, okay, we've tried to track them down and we're not having any luck, but I'm getting close, or they're ducking out and they're avoiding me. And it's a legal problem. I mean, he says nothing. He just sits there next to her with his funky hairdo and offers nothing.
Mm-hmm. I've noticed it a long time ago, but he might throw this. I'd hate for her to get an appeal won or even considered because of her investigator's inability to do his job.
Right. And he sat on the computer with Lonnie Dworkin supposedly for 4 hours one morning and couldn't figure out the gray key shit in the last trial.
Yeah. They gave her a $2 investigator. Lord.
He's a Dollar Tree investigator.
Right. Right. He's not even Temu worthy.
All right. You ready to wrap this up?
Yeah, I'm getting tired. I haven't felt good in 2 days, and it's been a long darn day with that trial. And we were wanted to watch this hearing, of course, but I do got a few things to review. And tomorrow I'll be covering the Koberger hearing all day. And fortunately, it starts a little bit later than my mornings with Karen Reed's having to start. So I'm looking forward to that a little bit. But this interesting hearing here for Miss Lori.
It is.
Especially, wanting the judge to recuse himself. If Gall didn't recuse herself, then Cannoni's not going to do it, and he's not going to do it. He has no good reason to. And I would have been really upset with that judge if he'd have said, you know what, I recuse myself. I can't deal with you. I'd have been like, no, sir, get your professional butt right back up there and you deal with her. Because she's not going to be the only person to ever want to defend herself. Just go do it and deal with it. I think he's the perfect judge to deal with her. Other ones may have already lost their cool with her. You know what I mean? It's hard to say.
He almost did today. He got close today.
Well, judges do sometimes, and there's nothing wrong with it if they have to raise their voice or get stern. That's what they do. So it wouldn't surprise me if he did bark at her, you know.
Well,
Wouldn't
it's a
surprise me at all.
rarity for him. It's a
I
rarity
know.
for him to do that. So it's even more impactful to me when he does, when he's like,
Oh, I
"Are
know.
you
I
done?
screamed that
Are you
first trial.
done?"
His
Yeah.
demeanor is, you know, what it is, but I've seen a lot more aggressive judges. So she's fortunate she's got the one she's got, because I don't know that another one would put up with her as much.
I don't think so. I don't think so. All right. So Rita, what was the motion? The judge mentioned something to exclude the Jeep Wrangler. So there were two motions filed by the defense at the end, and that was one of the two. We don't have that motion yet. It usually takes 3, 4, 5 days for those motions to get uploaded to the court docket. So I will keep an eye out on it, and I will share it as soon as I have access to it. And once again, librarians, thank you so much. Appreciate your support. Shore Life is starting my bail fund. Oh my gosh. If only. If only.
All right, guys. Y'all all have a great evening. I'll see y'all tomorrow if you come in for the Koberger hearing. Otherwise, I'll see you when I see you. But good show, Joe. Thank you for
All right.
getting
Thanks
it
for
out there.
coming up. I
All right.
appreciate
Thank you.
Salty. We'll
All
talk
right.
to you
Talk
later.
to you later. Bye.
Have a good night, everybody.
Good evening, come and find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime. We can make a difference if we put in the time. Good evening, come and find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime. We can make a difference if we put in the time. Oh, we can make a difference if we put in the time. Good evening, come and find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime.